just to open us up, and then we'll get started. Notice of the October 24th, 2019 meeting of the Board of Examiners for Land Surveyors was posted to the Board of Examiners website on October 17th, 2019. We'll go ahead and do the roll, and then we'll go from there. Jay Kaufman. Present. Tim Learfelt.
Present.
Jackie Dillahay.
Present.
And looks like we have quorum. If we can, we'll move on to the agenda. Well, before we begin, we do have one quick announcement. It appears that we do have a new executive director for the Board of Examiners for Land Surveyors, and I'd like to introduce you to her. It's Jennifer Peck. She sits here to my right, and she comes to us. She hails from Chattanooga and is an attorney there. Been in practice for well over 12 years, very experienced, and there's also been, she's known for some time that she was going to be coming here, so she's caught up, read the rules and the laws, and is ready to jump in with both feet. So we're excited for her, and of course we're not far away. There's plenty of support around her, and we expect that there'll be a smooth transition. We also have a new attorney, Maria Bush. She is next door with the accountancy. So she'll be joining us after this board meeting at our next one. In her place, though, we have Stuart Huffman. He's sitting at the very end there, her supervisor, and he'll be assisting with any board business that we may have in that regard. Unless there's any further comments, we'll just move on to the next piece. Is there any comments or?
They want to welcome Miss Jennifer to the Surveyors Board. I understand you've got other boards on your docket as well, but certainly want to welcome you here and look forward to working with you.
Thank you. I'm excited about it.
And I would like to congratulate Mr. Kaufman on his reappointment to the board for another 6 years.
Yes.
We're glad to have him back.
Thank you. Thank you. It's a pleasure being here.
Great. Thank you for that, Tim. Appreciate that. All right. For the agenda, any comments or questions? Do we have a motion in regards to adopting the agenda?
We were given prior to the meeting a letter from Galen Northcutt, who is a former board member. And he asked that we may be able to include it in discussion. And of course, the board understands that there would be no motions or anything about that because the public was not made aware of it prior to the meeting. So I would like to include that in our agenda. And I'd also, as the chair, like to ask for the ability to manage the agenda such that we can accommodate either the folks that are appearing before the board or any other issue we may need to do. That's something we typically do.
Yes, sir. That sounds fine. So we'll adopt the agenda with flexibility and also allowing for our former board member here to read his letter and to discuss that as well. So that would be great. All right.
Do we need a motion?
Yes, sir.
I'll make that motion.
I'll second that.
Okay. Have a motion second. All those in favor?
Aye.
Okay.
Great. All right. This will be everything will be included under the presentation, except for the applications for review. We're trying to make that nice and neat and tidy the best way we can. So. We'll move on. If you just hit the next page, we should be there with your July minutes. Is there any questions, comments on the last meeting minutes?
Have any changes in the minutes?
If there's no changes to the minutes, I'll make a motion to approve as written.
Second.
We have a motion and a second. All those in favor?
Aye.
Okay. Motion approved.
All right, great. We do have two gentlemen that are on the line. We are at this portion. We're at the appearing before the board portion. We have Roy Bullock and we have Alexander Finelli for application reviews. Their applications, if we come out of this presentation, will be available in that next document, and they are in sequential order. So Roy Bullock will be first. I trust you had an opportunity to look at those in advance. Do you have any questions or comments for our two gentlemen that are on the line?
Glenn, if it's all right, I would like Mr. Bullock to go ahead and make his presentation application, please.
Okay, great. Mr. Bullock, if you would just present your application, any comments or anything that you'd like for the board to consider, that would be appreciated.
Okay, thank you. It was December of 2015, is when my license was up for renewal. And I'm actually in Mississippi, in the central part of Mississippi, and have been. I actually lived in Tennessee up until 2003, and we moved back here. Now I have my own surveying business. And on my part, I did not realize that my license was expiring in 2015. Toward the end of 2016, in fact, December, as I was renewing some other states that I'm licensed in, I discovered that I had overlooked renewing my license. And at that time, I sent an email to a gentleman that was in charge of PDHs at that time, Mr. Cody Kimmer, in late December 2016. And I did not get a response until I got a phone call from him in early January of 2017. And he informed me and that since I had contacted him via email to send him my renewal and my PDHs, and that not to worry about my license being renewed, that everything was okay, and that he would take the renewal fee and take care of it. After about 11 months, I was contacted by a possible client maybe doing some work in Tennessee, and just as a safeguard, I looked on the internet just to make sure, my license was renewed and everything when I discovered it was expired. My understanding is Mr. Kimmer is no longer with the board, and the board asked me to renew my license. And through that process, I believe I need some help in understanding the plats that I've been submitting have not been approved, and I'm just trying to get a better understanding, as I don't have an advantage of working under a Tennessee licensee being in Mississippi, and I'm just trying to understand the process and what I need to submit correctly in order to possibility to get my license reinstated.
Mr. Bullock, if I may interrupt you momentarily and ask you a question. You speak to as though you have never been licensed in Tennessee when you say you're not working under someone in Tennessee. However, in your beginning of your statement, you made a statement that you were licensed through 2015 in Tennessee. Is that not correct?
Yes, that's correct.
Okay.
I'm sorry. Go ahead. I'm sorry.
Now, let me speak to your plats.
Okay.
Your original application submittal on your plats included land descriptions and plats that were stamped and dated after your license had expired. And that's what we at the board see is the paperwork that you submit with your application. And I personally find that insulting and quite frankly egregious in my mind that you would submit to the board a document dated after you already knew that you were not licensed by this state, and asking this state to approve you to become relicensed. I just have a hard time with that, so you may want to address that.
Well, first of all, I realized that after I sent it, there was no way I was trying to insult the board whatsoever. I guess I realized actually after I sent that I'd made a mistake doing it. But the way I'm looking at it, I'm here in central Mississippi, and I don't have a way of working under a licensed Tennessee surveyor that could say I did that plat under direct control under him. And again, the reason I did that, I was just confused where I thought I could use my Mississippi stamp that adhered to Tennessee standards.
I think, Mr. Bullock, if you had looked on our website, and we give a very detailed explanation of how the plats and the application can be submitted, and it clearly states, to my recollection, and I may be corrected, but it clearly states that if you're licensed in another jurisdiction, that you can submit a work product from that jurisdiction that has been so modified to meet the standards of the state of Tennessee for application purposes, and it can be certainly stipulated on that document that that's the reason that you have submitted that. So, I take it, let me say it this way, I take exception to your statement that you did not have any means or method of knowing how to properly submit that document.
Okay. Well, I mean, if that's your stance on it, my only question is there a possibility I can get my license renewed in Tennessee?
I think that possibility certainly exists, but I think it's to the point to where, I personally have reviewed your application 3 times. And to date, the first time that I reviewed it was in March of 18, and I think we're in October of 19 as we speak. So that's about 18 months worth of review off and on. And to date and to point, we have responded. I'm sure other board members have reviewed, because at least 2 members review at all times. But I just know what I have done. And I have responded very clearly, I think, on my candidate review sheet as to what is expected to be submitted for your application to be approved. I do not know what other members may have done, but I know what I have done. And to date, that has not been properly submitted to our board office, or at least for my review.
Okay, well, I'll need to get that corrected and sent back in, resubmitted.
Mr. Boyd, this is Jay Kaufman. Part of what we're seeing here, your application being deferred for deficient plats and descriptions is not uncommon. Others, in fact, I think one of the individuals we'll listen to here in a little bit after your call might be the same situation. I just got to ask. I got to ask the applicant sometimes when I'm reviewing these plats if you've actually sat down and read the rules and regulations to surveying in the state of Tennessee.
Yes,
Because if you just apply those step by step to your plats and to your descriptions, then you shouldn't have an issue. The problem that we're seeing is that you continually resubmit your plats and descriptions, and they're not following the standard basic rules and regulations. And they come back to us a second time, and we see that they're not following it. We defer it a third time. It comes back a third time. You're still not following them. And now what we're asking, or what you're asking us to do, is, can we do it a fourth time? And so, generally speaking, for myself, after 3 times reviewing plats and descriptions that don't follow the rules and regulations, that we've sent back to you with specifics of what to do, and then we ask you to appear in front of the board, and you don't even make it to the board to appear personally, which is a separate issue here that I have merits against. Can you see my impression here that the professionalism appears to be lacking? Can you see my point there?
I can.
Especially the point from a previous Tennessee licensee, who at one point obviously went through the application, went through the examination, has enough experience and education, and then allowed their license to relapse, and then comes back to apply again and cannot produce minimum standard plats and descriptions. Do you see where the issue is there?
Well, in all due respect, Mr. Cody Kimmer, I don't have an email stating this. The board cashed my check of $280, and he told me everything was fine, and I wouldn't be in this situation at all. I'm just, that's the point I need to make. The board took my money, and according to somebody with your board, said everything is okay, it's renewed, and now I'm taking a bashing for this.
Taking a bashing for producing substandard plats right now. That's what you're taking a bashing
Well,
for.
what do we? Well, okay.
The payment in your emails with Cody is a separate issue. My issue right now is that you're a former licensee looking to get relicensed, and you're producing substandard example plats.
Okay.
How can I feel confident allowing a licensee out in the general public that can't produce minimum standard plats to the board? How can I do that confidently and protect the public at the same time? That's where I have an issue.
Okay. Well, it sounds like this issue won't get resolved for me trying to get it renewed. So,
That's what I'm saying.
it sounds like you don't want to review it a fourth time. So,
I'll review it a fourth time. Every time you submit it, I'll review it.
Do we have any instructions for our applicant?
So let's just, I mean, I've taken, y'all have stood your point, told me your point. I'm a registered surveyor and more than there, and I meet minimum standards. It was just confusing to me if I could use a Mississippi stamp or Tennessee stamp. That's what was confusing to me. I couldn't understand it.
Okay, Mr. Bullock.
So I read the standards several times. So with that,
Mr. Bullock, let's pause just a moment. I would like to ask staff if they have any knowledge of this check that Mr. Bullock addresses.
Well, I will interject this. When you make application, you have to pay for that application. That's standard. So,
No, pardon me, Glenn. Mr. Bullock is referring to paying for his renewal in 2018. Is that correct, Mr. Bullock?
in January 11th, 2017,
Okay, 17. I apologize.
Mr. Kimmer informed me, well, let me back up. About January the 6th or so of 17, Mr. Kimmer informed me that since I emailed him prior to the 1-year grace period, everything was okay, not to worry, just send him the renewal fee and my continuing education, which I did. My check was cashed. My check was dated January 11th, 17. It was cashed. I have proof that the board cashed it, or whatever. And then my license never was renewed.
I think that should be further investigated by our staff, and I would greatly appreciate if you would forward a cancel check or whatever at that time, and any other correspondence you have possibly with Mr. Kimmer. And I think that we need to look at that. However, that fact being taken, I stand, as Mr. Kaufman has said about things, and I'm going to add one more thing to that, is, I might have been somewhat sympathetic to your cause had we changed the standards of practice since all this events had occurred. However, the standards of practice went in during the time that you were licensed as a Tennessee licensee. So not only were you responsible for making sure that you were renewing your license, but you were also responsible for making sure that you met those standards. So we are not, and Mr. Kaufman very aptly said it, we are not asking you to do anything that you didn't do when you were a official licensee of the state of Tennessee. So, at the end of the day, you have to realize that this board has to review the application based on the merits of the paper that it's placed on. And that's all we have. I wouldn't know you if I passed you on the street, and that's no disrespect. And that happens to us on a lot of applicants. But we have to review those applications based on our rules, regulations, and the standards of practice, and we have to speak to those if there's anything that's deficient, and that's what we've done. And I just like to say, I agree with Mr. Kaufman. You've not rised to the standard that we request on paper in front of us, and you're more than welcome to resubmit, but I highly encourage you to get us this information about this check, because if in fact, and this is what I don't understand, If in fact you sent a check in January of 17, the prior renewal would have been at the end of 15, okay? So that check would have taken you up to the end of 17, basically. Then you would have the void from 17 to now. So, you know, either way, if that check simply covered you for that prior biennial renewal period, it's not covering you for the present. So, in my opinion, you'd still be unlicensed in Tennessee. So you're still wearing the same set of shoes, but, you know, I want to give you every benefit of the doubt, and we'll review, you know, what information that you send to us. As far as I'd like to get that check issue resolved, and then we'll review another application. But I want to highly encourage you to look at the sample map on the website, look at the sample instructions, because I think that they can be taken care of, and I know they're correct because Mr. Kaufman prepared them. So, you know, the rules of the road and the direction is clearly there. You know, it's up to you to read it and prepare it properly in your submission to this board. And if you decide to do that, we'll certainly review your application. And if there's something deficient, we'll let you know. If it's not deficient, we'll approve it and move you on to where you can take your examination again.
Okay. Okay. So I would need to take the exam again.
Yes, sir.
State-specific exam.
State specific.
Okay.
Mr.
All right.
Hey, you got anything?
I just, with the events that took place in January 2017, I'm just curious why you didn't follow up to get some type of resolution with those events. I think I certainly would have.
Right. Well, I took Mr. Kimmer's. I took it that it was renewed, and I should have followed up, and I didn't follow up until November of that year when a potential client just called me and might possibly have some work in Tennessee, and I wanted to make sure that everything was okay, but I should have done it sooner. I just didn't dream that, you know, my check would be deposited and everything, and then it wasn't renewed. On Mr. Kimmer's behalf, he did inform me that although I made this $280 payment in December of that year, I'd have to pay an additional, you know, the additional $280 for the following 2 years to keep it current, which I know this is just me talking. I don't have it in writing, but, you know, I did agree that would be fine because I didn't mind paying to try to keep it.
So was your check for $280 or for $560?
My check was for $280, but of January 17. But he informed me in December 17 I was going to need to send him another $280.
Okay, I'm going to refer you to 6218-113. Speaks to expiration date of certificates, and this as a licensee, this is your responsibility. Certificates of registration expire on December 31st of each odd-numbered year and are invalid after that date unless renewed. It is the sole responsibility of any person registered as a land surveyor to renew the person's registration on or before the date of its expiration. That was no different when you received your license day one from the state of Tennessee. That statute has not been touched since 2001. So that's where we stand. I think we've said enough about the matter. Unless Glenn or Jennifer has anything additional, and we'll go from there.
Thank you, sir. Mr. Bullock, we'll reach back out with you with any further instructions, but right now we just need to follow up on the action items that were presented to us by the board, and we'll be back in touch with you. Thank you for calling in and for providing your comments, and we'll be in touch soon.
Okay, thank you for your time.
Thank you, sir. All right, next we have Mr. Finelli. If you want to go to page 18 of the application review, his documents will be provided subsequent. Mr. Finelli, if you would like to present yours and make any comments, that would be appreciated.
Yes, sir. I just want to start out by apologizing to the board for not being there, but I guess I was a little kind of misdirected and informed with that. When I spoke to Ms. Carney at the Tennessee Department of Commerce, I asked, specifically if it was necessary for me to be there, because if not, I work for the Army Corps of Engineers here in Nashville, so it's not far away, but I do have a full schedule, and which I could have, cleared and made accommodated had I known to be there. But so that's kind of my reasoning for not being there in front of you, which I do apologize for after hearing the last gentleman speak. But as many of you probably know, my application is probably a pretty unique one from what you're used to. And also kind of confusing at the same time for both you and myself. A little bit of background about myself is when I first submitted the application, I believe this January of 2019, I was a Chicago resident, worked for the Army Corps of Engineers in Chicago, and was pursuing licensing up there, which when it came across your desk first, you probably wondered why I was wanting to be licensed in Tennessee. Well, since then that's changed. I've transferred to Tennessee to the Army Corps here in Nashville, where I am the survey chief here for our whole Nashville district boundary, which covers, as you may know, quite a bit of Tennessee and southern Kentucky. So that's just a little bit of background of why I'm here in front of you, trying to be a Tennessee licensee now. With that being said, I've also had some issues with the plats. And I will say I have read through those statutes that you guys keep referencing back to me several times. And like Mr. Coughlin, I believe, said, I have physically gone through each item exactly to make sure it was on the plat. I did notice the last time I overlooked something, but that was based on a recent email from Ms. Carney at the Department of Commerce, where it said that I needed to also include a paragraph of my experience and of the actual work that I performed on each plat, on each survey. So I didn't catch that before because it's not in your statutes. It was something she provided separately in an email. So I don't know if that was what was holding me up, but like I said, I've gone through those statutes several times that, when it keeps being referenced, the actual numbers, and I've used your example plat that's part of the Tennessee example plats. I almost mirror copied it, I believe, this last time, just to make sure I had everything that you're looking for. And to go along with that story, I think I've surveyed and done plats in about, roughly speaking, 7 different states this year alone, due to my unique position with the Army Corps, surveying for, Chicago, which covers Indiana, Michigan, Wisconsin, Illinois, and then now down here in Tennessee, which I've gone from PLSS states, the Public Land Survey System states, to meets and bounds states of Kentucky and Tennessee. So there's been a lot of different, plat requirements of me, and moving my entire family from Chicago to Tennessee this July. That's no excuse for not meeting standards, obviously, but I think I've done my due diligence, ethically speaking, as far as to make sure that I dot my I's and cross all the T's for following Tennessee standards, as well as I could have. I know there was also some issues with, back to the uniqueness of my application with, when I first applied, I applied as an applicant with just an associate's degree and experience. And since then, I received my bachelor's degree in May, and so we updated that information. And then now again, I think we had to change it to, based on when I passed my PS, the education requirements prior to 2017. So, in short, there's definitely been a lot going on, to say the least, that has probably caused a lot of confusion on both our ends. And I'm just looking to get resolution of it, because I know it can be a great asset to the state of Tennessee itself and to you guys, and especially the amount of different private surveyors and survey firms I deal with daily to, help with our state projects and everything else. I'm just looking to move forward and become licensed, and I know it'll be a good asset to the state. So I guess I'm looking for you for some direction to see where I guess my shortfalls might be. At this point, I believe it's just with the plats. I haven't heard anything else of any issues with my application. Again, I don't know for certain, but there were some educational stuff, but I think that's been resolved. So as far as I know, and being a new applicant, which you may know, I've never been licensed in Tennessee before, but I think it may just be pertaining to the plats. So I guess I'll defer to you to, let me know where I stand and what actions I need to get things resolved.
Thank you, Mr. Finelli, if I said that correct.
Yes, sir.
I need to ask staff a question. Jamie, I do not see my review sheet in here.
I'll go up and get that for you if you want me to.
I reviewed it just recently. I see Jay's in there, but I do not see mine.
I'll go up and print yours off.
But, I don't want to reiterate something or say something wrong from what I've already reviewed.
Would you like to just circle back then while Jamie collects that information for you, and then we can move?
I was going to give Mr. Kaufman the opportunity
I see.
to speak while she does that, and
Sure.
then we can circle back if needed after that, if that's okay, Clint.
Yes, sir. That'd be fine.
Good, thank you, Tim. Yeah, Mr. Finelli, this is Jay Kaufman. Just to bring the point here, and you started off this correctly. So, I think I would have preferred you to be here in person. And the reason I say that is, number one, from your application, it looked like you were local. I think you confirmed that you are here in the Nashville area.
Yes, sir.
And just your physical presence here would mean a lot, especially toward the applicant's sincerity of being, considered for professional licensure in Tennessee. I would have preferred it. In fact, that was my specific request, was your presence. Now, Miss Jamie did not mislead you. You certainly are able to call in. That certainly is allowed. There's no problem with that whatsoever. Obviously, we're doing that right here. But I would have preferred your presence.
Understood.
But beyond that, and I understand your whole situation's been very dynamic. Chicago down to Nashville, moving the family. Your new role is if I understood, the survey chief there for the Corps here in Nashville. Obviously, it would probably be to your advantage to be licensed in Tennessee, and I understand that, and we're working on getting you there.
Yes, sir.
My issue has been that I believe I personally reviewed your application, including the plats, descriptions, education, I believe 3 times that I recall. I think at first it was some issues with some educational transcripts. There was some conflict there, perhaps, the courses that it had taken because you were applying under the 2-year degree and whether some courses qualified. I think we jumped through those hoops a little bit, but I think the plats is where I was having a bit of a hang-up. And while I did see some progression as the plats for each review that I went through were getting there, I did have to question as to whether the applicant, that's you in this case, was actually reading the rules and regulations verbatim for not only the plats, but also the section there for descriptions as well. It sounds like you have, based on your testimony there that you provided. It sounds like you have, but there were some specifics early on, I know, in the plats that I had some issues with that made me just question as to whether you really were taking this quite seriously that you should be. It sounds like you are. It sounds like you are. We're gonna get you there with your application. If you can just go through the step-by-step of what's required in the minimum standards, review the examples that are on the website. It sounds like maybe you've already applied that. Look at the description standards that are in there. Look at the standards for if you use GPS on the surveys. Make sure you include what your role was in producing the surveys, whether it's in the field or in the office. Make sure that the plats are stamped. If you have an out-of-state stamp, that's fine. Signed, dated, all those standards that we require. Just go through those step by step. The point I'm trying to make here, and this is to all applicants, is we're not trying to make this complicated. In fact, one of the points I made on the example plat that's on the website is to keep it very simple. What we're not after is the overly complicated ALTA surveys that while you may be very proud of your work on it, it's too much. And you're complicating the situation. So keep it simple. It looks like on one of the example plats I've got here in front of me, you're doing just that. Keep your description simple. Make sure you're including on your descriptions, who it was performed by, and just the step-by-step follow the rules that are in there. And I think we'll get you there.
Okay, and you've probably seen multiple different versions of plats. Actually, I know you've seen that based on what was submitted, and this last submittal was, I pretty much, I wouldn't say copied, but I mirrored the example plats that you show to keep it simple, like you had mentioned, and
absolutely.
I
noticed that. Yeah, I noticed that on the last submittal of plats that I reviewed, that it was definitely drawn back and simplified. I appreciate that. I'm trying to do not only yourself but all future applicants a favor here by keeping it simple. Don't overcomplicate it.
Understood. But as far as just to reiterate, I have read through those statutes several times because I don't like to fail, and this is kind of a fail for me. I'm not used to it. So I read through them several times, and I guess I'm still missing something, but. I would, every time it mentions what needs to be included, I would make sure it was on there. And so it wasn't very helpful up to this point, I will say, just to refer back to the statute number because I understand what that number is and what's involved, and it does list the items that are required on the plat. And I'm not saying I'm at a loss, but, based on this conversation, after we hang up, I'm going to go back and read it again just to because that's my due diligence in my nature to do. And I'm almost at a loss at this point because all the required things that I can think of and have read are being shown to my knowledge at this point. I'm just thinking based on memory now. I don't have one up in front of me, but and like you said, you've seen the progression because I have caught some things that were overlooked or missed, especially my involvement on the surveys, and that's still unclear to me if that's actually shown on the plat itself or as a separate paragraph, which is the way I understood it from Ms. Carney. So maybe that's the part of it I'm lacking because that's not mentioned in the statute. So, but I'm almost at a loss. Not that I'm giving up by any means, because like you said, I will get there one day. It's just my drive and my nature. But to make things easier on us both and make sure I get there and am educated, properly with doing these, in the future. I'm definitely looking forward to getting to that point.
Just kind of change the subject, but still on topic. Can you review with us what your history has been serving under a licensed surveyor in terms of years of experience directly working under a licensed surveyor?
The only part of my career that I have not worked under a licensed surveyor was the first 4 years of my career from 1996 to 2000, where I first learned surveying in the Air Force. We didn't have licensed surveyors in the Air Force then. That I worked under anyway. After 2000, I went to the private sector for 8 years and worked under multiple licensed surveyors then. Started with the Corps in 2008 in Chicago and worked for multiple licensed surveyors, both as, either with contractors or with licensed surveyors from our division, which is multiple states that, they may have been licensed in multiple states. And even being here in Tennessee, I am the only surveyor here at the Nashville district right now, but I technically work under and use Ernest McCarty, who is the Huntington district survey chief there, who's also licensed in the state of Tennessee. So I've been looking to him to help me with these plats even, and you may have noticed his name on one of the original plats that was submitted even for the state of Ohio. It's just we are unique with the Corps that we cover multiple states. So I have worked, to answer your question, worked directly under licensed surveyors for quite a long time, and licensed engineers, to go along with that.
Okay, Mr. Finelli, Tim Lingerfeld again. I've been given my review sheet from September 27 of this year. I think that Mr. Kaufman is beating the correct drum. In your application, it doesn't really allude to the amount of experience under a licensee that you actually have had. And I think that's where the roadblock currently is, because the remarks that I made on my candidate sheet were that I did not see 6 years experience under a licensed surveyor, which would be required under the method that you're applying for licensure. And that was my stumbling block, and that was why that I had asked as well for you to appear before the board and to clarify that. And I think that you're in the means of doing that. I think that from what I'm hearing from the conversation, if you could provide that information to us, that, you worked for John Doe surveyor from here to here, maybe even a letter from that surveyor, so that would accumulate at least a minimum of 6 years as required by statute. I don't think that I would have any further issues with your application.
Mr. Chairman, I didn't review it, so I'm at loss as far as all the details, but I thought I heard him say that he just recently obtained his bachelor's. Now, the application may not be submitted as such, but that would change the requirements some. If that's the case, it may require resubmittal, but.
Well, let me say this, Mr. Dillhay. I reviewed, Mr. Finelli, I reviewed your education, and certain things are required depending upon whether you're applying under BS or AS or even high school. And your last application was submitted under high school plus 10, which I think is appropriate, because the educational courses that you took, although they were surveying related, did not completely fit into our category patterns based on the type of bachelor's degree that you have. So you're in the system with the best way to be approved for taking the TS exam. And like I say, the only thing that I need is just to see some type of verification from some of these licensees that you've worked for that would tally up to 6 years, and primarily after the time that you got you passed your FS examination, which was in 2011, and it's obviously 8 years out now. So I don't think that you would, from what you've said, that you would have any problem obtaining that and getting that to us. And from my standpoint in review, I think I would be able to approve your application for the examination. And that would be something that could be very timely relative to your timeline as to how quick you get it to us and so forth. Yes, Jamie.
Page 43 shows. Second one, it shows 2009 to present.
I don't dispute that, Ms. Jamie. However, the individual that has signed this does not indicate that they are a licensed. Yeah, up here they do, but they didn't stamp it. They didn't follow the rules. I mean. You know, again, Mr. Finelli, it's my opinion that if you would have this gentleman, and I probably will butcher his name, I speak East Tennessee English, Coventine Fidalis.
Fidus, yes, sir.
Okay. I would think that if you would have him certify that from the time that you passed the FS examination until now or whatever, if in fact you are working under his supervision and et cetera for licensure, then I think that if you could get him to produce just a brief letter to that effect, then if he can do that, certifying that, that you have have been working under his supervision and so forth for that window of time, I don't think I would have any problem approving your application.
Okay, I will definitely reach out to him and see. I don't see any reason. He's for my other state licenses, he's definitely submitted, recommendation letters and what have you for those states as well. So I don't see any issue with that from him.
So basically, here would be the roadmap. You would reach out to him, get him to do that. You would then get that back to Miss Jamie, and she would disseminate that, I guess, to myself and Mr. Kaufman, since we reviewed your application, and we would do the appropriate candidate review sheet, get that back to her, and then she would notify you as to what you need to do from there.
Sounds good.
And just to make sure, for clarification purposes, when we say certify, he needs to make sure he stamps and signs it.
Yes.
So that's just a further evidence of his licensure in I guess, Illinois.
Okay, will do.
All right. Unless there's any more comments, I think we have a path forward then for Mr. Finelli. He has his instructions. We can move on to the next agenda item. Is there anything else that the board would like to address, or can we close this one on and move on? Or are we? Okay, great. All right. Thank you, Mr. Finelli, for calling in. And if you have any further questions or concerns, please reach out to our department, and we'll do the best we can to address those.
Thank you, sir. I appreciate it, and thank you guys for taking the time to speak with me.
Thank you, sir.
Thank you.
All right. Looks like the next item is TAP's representative, Mario Forte. Are you here, sir?
Not here.
Not here.
Okay. Well, is there a TAP's representative in the room? Okay. Maybe Mr. Northcutt?
Well, we all belong to TAP, so.
Okay.
We're good.
Okay. It looks like Mr. Lucas is here as well. Since we asked for flexibility on the agenda, is there any place that you'd like to place Mr. Northcutt or Mr. Lucas? Mr. Lucas is one of our providers, our education providers. Maybe we'll handle that when we get to the education report.
Yes, sir. I think that it would be appropriate to allow Mr. Lucas to speak when we get to the education report. And if it so be your pleasure, we'd like to take about a 5-minute break.
Yes, sir, very much indeed. We'll take a break.
Thank you, sir. Coming. I think that's falling away.
All right, gentlemen, we are back on the record. Okay, where we left off was that we were heading into we talked about, we already checked off the TAP's representative, and we had Mr. Lucas here, and then we have Mr. Northcutt. Is there any order that you would like to proceed?
Yes, we'd like to stay with the agenda at the moment and go ahead and go to the education report, at which time I'm sure Mr. Lucas may like to address the board. And as far as Mr. Northcutt, I think he's going to be with us for just a little while.
Okay.
We'll get him here directly, but we've got some pretty heavy lifting, I think, with the education report and the legal report. So I think we can wedge Mr. Northcutt in with his patience and diligence.
That sounds great. Thank you, sir. Thank you for that direction. Then we'll move on with the education report. As far as for process, as you can see, we have about roughly around 50 courses to look at. Some have been approved. You'll see on probably page number 13 and 14 of your presentation, we have those that have been reviewed and have been approved by 1 or 2 members. If they have 2 members, of course, it's approved, so then we're good to go on those. But where there is 1 approval, and then what we need to do in that regard is it's been technically deferred, and so then the board will need to make a decision on each of those about what they would like to do with that. That's page 13. Page 14, courses not yet reviewed. So we'll talk about those as well. And the pages prior are just basically the formal listing of those courses. So our focus will be on page 13 and page 14. What we'll do is we'll just go line by line on each of those and then have that discussion where we need to. If there's a yes, there's no discussion needed. We'll memorialize that and track those as we go. Then we'll read back those all at once and then approve those or approve those recommendations formally and enter that into the record. Is there any comments, or will that work for everyone, or is there any other process that's more amenable?
We've had
I would think it'd be appropriate to have Mr. Lucas speak before we make any kind of recommendation. A lot of them are his.
And I would like to understand when these courses were submitted so that I have some feel of timeline relative to our advisory board.
And I have a general question. I just want to make sure that what we're looking at here on paper is the same thing we're looking at here. It's just in a different format. Is that correct?
That's correct, yes, sir.
Make sure they were the same. I wasn't looking at additional.
10, 11, and 12 is exactly what's on the paper, and then they've condensed them over here.
That's a format that you're familiar with. Typically, when we send it to the Education Review Committee, they send their approvals, and then that's presented in that formal report. So we know you're used to seeing that, but you'll notice most of that says pending because the spreadsheet next to that is what we're talking about. You know.
September the 9th is when I submitted these and then I emailed again on October the 11th.
Okay, so if I understand you correct, Ms. Jamie, there's 50-some courses here. They were sent to the advisory committee on September the 9th. Is that, did I say that correct?
Yes.
Okay. Okay. Thank you.
All right. Well, we'll jump right in then, if that's okay with you.
Yes, sir.
Mr. Lucas, if you would like to approach the stage here, I'll give you my mic.
Can everybody hear me, or do you need it recorded? Okay. Okay. Thank you very much. I appreciate being here this morning, board members and staff. The reason I'm here and asked to be on the agenda was we are a continuing education provider, my company, Lucas & Company, and we've been doing that since about 2008 with this vehicle that I call the Lucas Letter. And it's a pretty standardized, well, let me grab it. It's a pretty standardized document. It is, and one of the reasons I'm here also is to try to get a better handle on what it is you're looking for when we're submitting, courses for approval. And also we have a denial I'm just curious about. So those are the two issues I'm here for. But the vehicle we have is called the Lucas Letter. It's a 2-page newsletter. It's pretty standardized. And what in this newsletter we go over a case that we've done research on that has to do with surveying issues, business issues, liability issues, all things that surveyors should be, that I talk about in my seminars that surveyors should be aware of. The law that surveyors should be aware of in their daily practice. And then we have a 10-question examination that they can fill out and send back in. This is a typical examination. It has 10 true and false. It has 10, 5 true and false, and then it has 5 multiple choice questions and answers. And we also have an evaluation form that we have people fill out to get feedback. And then, of course, we have a certificate that we award them with a 70% or greater, passing on the exam. The exam comes from the 2-page letter and the attached case. These packages, the letter as we call it, can vary in size depending on the number of pages that are in the case. This one that was denied, Principles and Practices 2, it's fairly large. It's about 25 pages. They're not always 25 pages. It kind of depends on the case. But on average, over a year, we offer yearly subscriptions. Over a year, the feedback we get from our evaluations is it's taken them about to read the letter and to do the test. Some may be longer than others, some may be shorter than others. It's taken about an hour and a half. So that's, this is hands-on stuff. And I know you guys as professional surveyors have taken courses before, and you go straight to the test and you're done in 15 minutes. They're not going to finish these in 15 minutes. Matter of fact, my wife thinks that we're not awarding enough continuing education credit for these. And I wanted to also make it clear, because early on when we started submitting these for approval here in Tennessee, we were getting denied and not. We were only going to get like maybe half of the credit that we were going for, and we were getting denied because we're only accrediting an hour and a half to do these newsletters. And I think at that time your lowest, the lowest amount that you would approve would be a 1-hour course. But I think the confusion there was this isn't an online course, and I think at the time that y'all were only awarding half credit for online courses. This is a correspondence course, and it's pretty clear. Y'all have made it clear in the law, the administrative code, that correspondence courses will get full credit. So, and the difference, of course, is an online course you're going to take completely online, and you're not going to have any interaction with the teacher. With a correspondence course, we're corresponding with the people who are either our subscribers or they purchase one of our courses. I'm available to them. My wife is available from an administrative standpoint. So there is correspondence that takes place, and they send us they send us questions about the examinations, and we send them answers, and so there's a lot of back and forth. It does take a lot of time, actually. So I'm not trying to compare Tennessee to any other state in any kind of a bad light, but we do this in Florida, and it's pretty much the same thing. Every month it's a standard deal. We have a 2-page letter, and we have an attached court case. They're not all going to be Tennessee cases, obviously. They're not all going to be Florida cases. They're from across the country, but the principles are generally the same. And they have staff approvals. I mean, we send them in a description. They know what our newsletter's about, and we get staff approvals in one day. The next day we get a number, a course number from Florida. Not all states require pre-approvals. That's the one issue I came here about, was to see, what it is that we need to do with the Tennessee board to get approvals, because we don't have a lot of approvals, and we have a denial on this one. And I was just curious, and maybe you can address it, maybe you can't, but our Principles and Practices 2 newsletter we submitted sometime last year. Obviously, we submitted in time for it to get a denial. And I was just curious what would be, why this case. The only thing I can think of is it's Lawyers Title versus Doubletree Partners is the main case, which has to do with title insurance, but also has to do with the survey exception in the title policy. Surveyors are not acutely aware that a title policy, so we were going through a series of looking at court cases involving surveyors and title policies, because a lot of surveyors aren't even aware that the standard ALTA title policy provides survey coverage. In order for the survey coverage to come out of the standard policy, you have to, the title company goes to Schedule B and puts in what we all refer to as the survey exception. So they do it in kind of a roundabout way. They have the standard coverage, but they go to Schedule B and they exclude the coverage. And the coverage means that the surveyor who did the survey, if that survey is, and that's what happened in this case, the survey was proffered to, was turned over to the client, who then was talking to the title company about getting title insurance, and the title company upsold them to leave the survey coverage in there, so they took the exception out of Schedule B, and now the results of the survey were what was actually being insured here. So in other words, the surveyor was put into the insurance business. Now, it might not have seen from just a description of the course that, well, this doesn't have anything to do with surveying, but I don't know. I don't know why it was denied. Matter of fact, it probably should, because of the thickness of this thing, if it was looked at individually, it'd probably take about 2 hours, maybe 2.5, depending on the person's acuteness to go through this particular letter and then read the questions and get a 70% success on the test. So those were my issues, and so I'm here to find out, and I guess maybe listen to your report and see what it is that we need to do better in order for us to get approvals on our courses.
First off, I want to thank you for attending, Mr. Lucas, and also for your presentation. Secondly, in addressing the course that you have spoken to as being denied, that course is not in the list that we are dealing with today, and apparently was denied at some time prior. So we would have to, have more information about that as to when it was denied and so forth. So as far as the board being able to address that today, I don't know that we have the ability to do that today. And I'll certainly give you my word that we'll look back and investigate it and see what is going on in that regard. But as far as these other courses, I think the spirit of where we were going here was to allow you to speak to that, and then after you speak to it, we're going to go through the normal process that we go and have our discussion and deliberate and decide as to what we do with each of these courses.
Well, that's what I was asking for.
Okay.
Mr. Lingerfeld, I appreciate it. Thank you
Yes,
very
sir.
much
Thank you very
for being
much,
able
sir.
to address you this morning.
Okay.
Thank you, sir. Appreciate your comments there. That's correct. We're focused primarily on the list today, so as we work through that, and Mr. Lucas, thank you for your comments as well. And I imagine if the board has any other questions, then please just approach the mic and then address those as they. Thank you very much. All right, so we'll start with the first one then. It's there again on your iPads. I believe it's 13. Yes, page 13. All right, and I'm going to keep a running list of where the board lands on each of these, and then we'll repeat those at the very end, and then we'll have a vote on those at that time. Okay. First one, we have both yeses, so there's no need for discussion there. Same with the second. Surveys Historical Society. So we can move to a red vector, algebra for engineers and others. Do we need to have any further discussion on that, or are we satisfied where we're at on that? I know all of you have had an opportunity to look at that, review that. Any comments?
The comment that I want to make, Glenn, is this. Continuing education is intended to foster the improvement and the betterment of the licensee. When I see a course like Algebra for Engineers and Others, I think all that course, in my opinion, is accomplishing is some type of antiquated review of where you came from. In our ever-changing world, we need to be, looking at things that we're dealing with, whether it be technology or whatever it may be, court cases, etc. And I see a course like that, that's just not, to me, that's just not serving the licensee with going to, I don't want to use the word basic, but a more simplistic type of structure.
If I could just follow up on that as well. I also denied that one for much the same reason. And it kind of goes back to a previous meeting we had with a gentleman that tried to present a course for, I think it was on horizontal curves, I think. There is value to each of these courses to its certain place. And I think this one, as well as previous ones that we have discussed, were of a strong value to perhaps the future licensee in their progression towards becoming a professional. Again, to reiterate what Tim was saying, I agree wholeheartedly that the purpose of the PDH is to continue the education of the professional, one that's already attained that level. And for that reason, I chose to deny the Algebra for Engineers and Others.
Unless there's any further comments, that's a no. So we'll just we'll put that down at that and move on. Boundary agreements was a yes for both parts. Now, CPM scheduling Part 1 and Part 2 by also Red Vector. Any comments in regards to there, or any need for revisitation? If not, we can put no on both since we had a no.
I think I was the one that denied on those. I think that was just sheer, I needed more information, more explanation as to how this relates to the profession of surveying. On the surface of it, again, this is all I had. On the surface of it, it did not pass the mustard for me. But I think perhaps if I had more information, it could convince me otherwise. But at this point, I would deny.
Perhaps a justification of some sort, not just the material itself.
I can't think of, CPM's critical path method.
Right.
It's used in construction all the time. Look around town, all these tire cranes, every job there has a CPM. I can't think, and Jackie's worked for a large engineering company, I can't think of ever using a CPM on surveying projects, even developmental projects. And it may be. Somebody may use them. I don't know. But I'm like Jay. Without any further syllabus, I'm a no.
Very well then. Thank you for your comments in that regards. I do think a justification, like you stated, is helpful. We find some, help us connect those dots. So, all right. We got a yes on the next two, so nothing there. Or it's actually all the way down on the rest of the Red Vector courses until we get to Mr. Lucas's courses, which these were all deferred. So we do have one yes, and then but we have 3 board members here today, so we can have the discussion on the rest of these as to what we want to do on each. So I guess we'll start with Tennessee ethics, and perhaps maybe have that discussion about Tennessee standards as well. Is there any discussion in regards to that? You've already seen, of course, the material. Any comments or maybe instructions for Mr. Lucas since he's here today?
I did review these, and I did approve them. It was my experience through Mr. Lucas's coursework. I don't know that I've ever had the pleasure of taking one of his newsletters. I think he referred to the Lucas letters, I think it was. I'm certainly familiar with them. I don't know that I've taken one before, but certainly his presentation here did assure me, certainly of the quality. I've certainly seen his presentations before, the quality of the content there. And so personally, I felt comfortable with the submittal of each of these courses that he listed here.
Especially after he spoke to us today, I would have no problem approving them also.
Just as a reminder to the board, where there's 2 approvals, that's an approval. That's always been standard protocol. So I'm going to list these as yes. So when we get to the vote, it's not that you're necessarily voting for that you necessarily approve it, except for we're just agreeing with our prior protocol that we have 2 yeses, and therefore we're approving the entire report. Okay. All right.
If I may speak to it, I mean,
Yes,
I understand you have your approval, but if I may speak to it, I've never been in favor of a half an hour on courses. I know our statute does not speak specifically as to it being even hours or whatever, but that's, I guess, more of a personal preference. And I want to extend to Mr. Lucas the same thing Mr. Dillahay and Mr. Kaufman have said. I appreciate, number one, you attending. Number 2 is addressing what you do. I want you to understand I appreciate what you do because you do it in a very professional way. And it certainly has helped me have the eye-to-eye contact with you and to listen to you as to what you've said about what you're presenting. The concern that our board always has is trying to make sure that our vendors provide the best continuing education possible. And I mean, I know this is what you do for a living, but you wouldn't do it if you didn't care about the profession. And that's very, very important. So I wanted to say that to you and thank you for that. And like I say, I'm just not a big fan of the half hours, but they are what they are. The only concern that I would have in the future is any sort of repetitive nature that some of these letters may have from a standpoint, we do have in statute that you can't repeat a course, but after every 3 years is the only time you can repeat one. So I just pitched that out just for your purview. If you'd like to address that, Mr. Lucas, please step up there.
Yes, sir. Thank you. Mr. Chairman. We do have, we do repeat, like, and you've seen it in our numbering, says principles and practices 1, principles and practices 2, but we go over we're going over different principles and practices for land surveying, and then using other examples, other cases. It's always new material, but we might be re-emphasizing a few things, like following in the footsteps, like original surveyor, line run on the ground is presumed to be, the correct line. Those, we're re-emphasizing in some cases those principles, but so that's one of the ways that I'm putting the newsletter together. Taking a theme like principles and practices, or easements, or rights of way, or boundary adjustment, that kind of thing, and finding cases where we can bring, put some flesh on the bones kind of a situation. And just real quick, on the submittals that we did for standards practice and code of ethics, two things. First, we're using the the Tennessee Code of Conduct for that program. We're using that with some commentary that we put in there, and we're testing on that. And since you only need 1 hour, we requested an hour on that one. And the same for the standard practice. We're using the text from the standards with some commentary and then testing, and 20, and both of those are 20 questions, 10 true and false, and 10 multiple, choice. Thank you very much.
Again, thank you very much. Glenn?
I just think, and I may be wrong here, but the requirement that they cannot use the same topic every 2 years, is that not on the licensee to make sure he takes the proper
Yes. Yes.
the proper seminar or
Yes.
continuing education and not retake the same thing
Right.
within a 2-year period?
Yeah. It's 3 actually.
Yeah. Okay.
Yeah. Yeah.
It takes us to page 14 on your iPads. These are the ones that have yet to be reviewed. Of course, we're familiar with some of these sources. Red Vector, of course, we've approved some of their course TAPS, their conference. They're pretty well vetted. Before we begin line by line, are there any comments or exceptions to any of those that the board members would like to out or that they would like to make in regards to these?
First I've seen this list. A moment or two to get through it. I think we'd be able to better respond to you if that's all right.
Question for the board is, are surveyors still allowed to do perk tests?
Yes.
Okay.
I wouldn't touch one, but we still can do them.
Yeah.
It isn't isolated down to the soil scientist now? It's not? Okay.
Not to mine, and I'm 99% sure of that.
No, actually, soil scientists actually still do some perk tests in the state of Tennessee where the soil is.
Questions about would be the government land.
What you're saying, my argument in favor of the government land systems is there are some sectionalized areas on the
in Tennessee.
extreme southern border of Tennessee.
There are,
And Chattanooga, too.
there are in Oak Ridge also.
Is it?
Yeah,
Okay.
yeah.
Okay.
But it's
I'm familiar with
public
them.
lands, or it's
There
just
are in
a-
Oak Ridge, yeah.
So I tend to approve that one.
Yeah.
But again, I do have some discussion. I assume we're on the record here? We are? Yeah.
Yes, sir, that's correct.
I do have some discussion, and I certainly would appreciate more information from TAPS on the two, the HR-101 and the other one, the Commish-Taxation for Employers 101. I would need to see some information on how that directly relates to the professionalism of surveying.
Unless there's any other comments from the board, we'll put those down as deferment, and we'll just, and then get that information back to you.
I can get us some kind of syllabus or something. Obviously, had Mario been here today, I'm sure he could have spoke to it.
Very well, then, as far as those two goes, those will be presented or represented at the next meeting, and we'll get.
I assume as soon as Jamie would get something, she'd
That's correct.
email it to us.
That's correct, thank you.
Yeah. So that'd be a quick turnaround.
Yes, sir, that's right.
Okay.
Other than those two, I don't have any issues with the others unless other board members do.
Okay.
That pretty well concludes the
think
education
so.
report, so I think we need a motion to affirm what actions that we have discussed already.
Let me just revisit that to make sure that is the consensus or the recollection of the board, and then at that point, we'll take motions. All right, for the first two on page 13, Surveys Historical Society, those two were yeses. Red Vector, Algebra for Engineers and Others, that was a no. Red Vector Boundary Agreements, yes. Red Vector CPM Scheduling Part 1 and Part 2, that was a no. And then the remaining, of course, is on this page were yeses. If you go to 14, we have yeses for those course, except for TAPS 52nd Annual Conference, HR 101, the Commish Taxation for Employers 101, for which we need more information. And then that information will be sent to you directly upon once it's received. All right. If that is the recollection and the position of the board, do we have a motion to approve this education report?
So moved.
All right. We got a motion from Mr. Kaufman. Do we have a second?
Yes.
Thank you, Mr. Dillahay. We got a second from Mr. Dillahay. All in favor?
All those in favor?
Aye. Thank you, Chairman.
Okay.
All right. That.
Say one more thing.
Yes, sir.
I'm going to head back to Birmingham, but I really appreciate your allowing me to speak here this morning.
Thank you very kindly for
Thank you.
coming. We appreciate you.
All right, Chairman, if we may, we'll move to the legal report.
Have to.
Oh, we don't.
Miss Erica's been waiting all morning over there. We got to get her going. She's got her coffee.
I got my
She's ready.
coffee.
She's ready now. You got your seatbelt too?
I do this time, yes, I do.
Atta girl.
Ready.
I'm buckled in.
Atta girl.
Okay, so number one is 2019-056221. And remind me, would the members like for me to read verbatim the whole thing? Is that good? Okay. Complainant alleges respondent added part of complainant's land to respondent's client survey, resulting in a dispute between them as neighbors. Counsel notes complainant is not the client for whom the survey was completed. Specifically, respondent completed a survey for complainant's neighbor in December 2017, and complainant alleges he did not look at the previous deed of record before completing the neighbor's survey and created a new deed with 1/8 acre of complainant's property. Complainant further alleges respondent would not respond or communicate with complainant regarding this matter. Complainant states that the issue can be cleared up easily if respondent would simply communicate with her and asks us for assistance. Respondent responded to this complaint and explained that he was out of the office for his daughter's wedding and a vacation for 10 days, but has since discussed this matter with the county property assessor, and the closing attorney associated with the survey at issue. Respondent further explains that there is an ongoing property dispute between complainant and his client, the neighbor. Therefore, respondent was instructed by his client not to discuss the survey with the complainant directly because both sides are represented by attorneys in the property dispute litigation. Respondent feels complainant is using this complaint to bully the property assessor, the closing attorney, and now the respondent through any means necessary to gain advantage in the civil litigation. Complainant provides no documentation or further detail to support this complaint and fails to allege that respondent committed any violations, only taking issue with the fact that respondent failed to communicate directly with complainant once attorneys were hired. Respondent denies any misconduct regarding the survey, and there has been no evidence presented of any violations. This matter is presently suited for civil court as a boundary dispute between complainant and their neighbor, and therefore my recommendation is closing this.
I agree. I see nothing in here that relates to anything that we have to deal with. It's a communication issue. Obviously, there's some legalities involved with it. The two property owners obviously have some issues there in civil court. I don't see any action here that we even need to be dealing with.
I agree with exactly with
Mr.
that.
Eric, I just would like to ask a question.
Of course.
Seems to me we have a method of dismissing so that if the civil case happens and something comes back, we can still revisit it.
We can hold it in a monitoring status until the civil litigation is over. We'd have to vote on that, and that would be, the recommendation would be to hold it into a monitoring status. And if that was approved, the procedure would be that I would reach out to the attorneys involved in the civil litigation and ask them to follow up with me as soon as it's concluded, and then when it is concluded, re-present it to you.
If that's not necessary, then if we just simply dismiss, or for anything else to happen, it'd have to be a new complaint. And
Yes.
that new complaint would be based on litigation, and the dismissal of this would not hamper us in dealing with the new complaint. Is that correct?
Correct, absolutely,
Okay.
in no way.
I read this complaint. It's not
Not
alleging that the respondent violated any
Right.
or it's the civil matter really.
Right, I mean, obviously there's a boundary dispute, which is before a court, and the only thing really that I believe the complainant reached out to us for was to make the respondent do what they wanted them to do and communicate with them in the way they wanted to. And I felt really comfortable with the fact that respondent communicated properly. It might not be the way the complainant wanted it to be done, but it was proper and respectful of the litigation process going on.
Was it truly the complainant's language that said that the respondent created a new deed? Because that's just the word. That wording was a little odd because surveyors don't create deeds.
Can I look at the complaint
Sure.
really quick? I want to
Sure.
make sure that I know.
That was more of a question of curiosity.
Yeah.
It's not going to change
Of
what
course.
we're going to do here in a minute.
The words of the complainant were, "It is obvious respondent did not look at the previous deed of record to complete the survey, and a whole new deed was made."
Okay, so the surveyor, the respondent did not do the deed. That's what I thought. Okay, is there any further discussion before we ask for a motion?
Move we accept the recommendation and dismiss.
Okay, we have a motion and a second. All's in favor?
Aye.
Number 2, 2019-057861. Complainant alleges respondent committed errors on a survey. Counsel notes that complainant is not the client for whom the survey was completed. Complainant specifically alleges that the marks in the survey were off by as much as 2 feet in more than one location. Complainant further alleges respondent was hostile and rude when contacted and is not being cooperative or answering any of complainant's questions. Respondent and their client both responded to this complaint and attached a video from the day respondent completed the survey at issue to show respondent's actions when conducting the survey. Respondent was asked to stake the boundaries of the 16-foot right-of-way on a private road, which leads to the client's property from a road in another development. Respondent's client was having issues with complainant backing out into the right-of-way when leaving the property and wanted to know where the right-of-way boundaries were located. Respondent assumes complainant checked the stakes himself, leading the complainant to make the allegations that respondent made errors in the survey, considering complainant references no other surveys in the complaint. An expert review was conducted of this survey at issue. The expert found no violations, incompetence, negligence, or misconduct, and noted that respondent provided much documentation and explanations as to how complainant, someone who is not a surveyor, could have come up with an erroneous conclusion and allegations against respondent. Counsel and the expert both recommend closure because there is no evidence of any violations.
Discussion?
I mean, the one thing that I do see in favor is that it appears that the respondent provided documentation. I assume that means that they were, easily accessible, was not trying to resist or hold back of any kind of information.
Oh, fully cooperative.
That's what I'm after, fully cooperative, and that's definitely a positive. But other than that, I think having an expert review of it, having found no violations, that goes far with me, and so I agree with counsel's recommendation to dismiss.
You have that form of a motion?
So moved.
Second.
Have a motion and a second. Is there any further discussion? All those in favor?
Aye.
Aye.
Okay.
Number 3, 2019-059691. Complainant alleges that they asked respondent to complete a survey and only received a preliminary survey and not a completed one. Complainant alleges that efforts to contact respondent have been unsuccessful and claims that respondent's failure to produce a completed survey became detrimental to a purchase transaction. Respondent states that complainant was aware that respondent was going on vacation, and in anticipation of this time away, the preliminary survey was given to complainant prior to the respondent's departure. Respondent further states that complainant entered into litigation with the seller of the subject property the previous year. Therefore, respondent was barred from entering the premises during that time. Respondent explains due to these circumstances, the process took approximately 1 year, causing the schedule to become backlogged for 2 to 3 months, also being dependent on the weather during that time. Respondent agreed to provide the complainant with the completed survey within the next week. So since the complaint has been filed, I have reached out to the complainant and asked for a status update as to whether the completed survey has been received. And the complainant states, quote, "To be fair to respondent, he has since been responsive after my rebuttal submission. Respondent submitted a second draft of the survey." Complainant further states the second version was sent to the lender and title office for their review and any questions or comments. Respondent told complainant that once everyone reviewed it and sent their questions and comments, respondent can plot the finals for delivery. So at this point, there's no evidence of any violations, and therefore, counsel recommend dismissal of that. And I think, Carol, didn't we ask again the complainant, and what was the answer? Okay, so right before this meeting, we reached out again to the complainant to see if everything was satisfactory, and we didn't get a response.
If what I'm reading here, there's kind of a good news, bad news. The bad news is that the complainant had to use this method to get the surveyor to deliver the product, unfortunately. It's kind of a use of the system that I really don't appreciate, but obviously there were some bad business practices, or communication practices, I should say, originally between the two for whatever given reasons. I mean, obviously there were some issues in there, obviously, and some delays. But on the positive side, it does sound, again, like the respondent, having realized that the complaint was filed, has responded in a positive manner to the client, and it looks like they're on their way to getting it resolved. I agree with counsel's motion to dismiss. Their recommendation to dismiss, I should say.
In that form of a motion?
Yes, so moved.
Have a second. Okay, we have a motion and a second. Is there any further discussion? If not, all's in favor?
Aye.
Aye.
Thank you. Number 4, 2019-066711. Complainant alleges that respondent completed an inaccurate survey for a neighbor claiming that no pins were ever located. Counsel notes the complainant is not the client for whom this survey was completed. Complainant states that they have been trying to contact respondent to discuss the survey at issue but has not been able to get a response. Complainant claims that respondent entered the property while complainant was away on vacation and drove a railroad spike into the ground with a pink ribbon attached. That was not there when the complainant left. Complainant alleges that the survey at issue was submitted while complainant was out of town. Respondent responded to the complaint and confirms that he completed a survey for the respondent's neighbor and notes that the respondent's client and complainant have been involved in a boundary dispute regarding the property line. Respondent states that he was able to locate almost all of the corners of record while doing the survey, except where the line intersects the south boundary of complainant's property. Respondent states that this area had been graded and gravel had been brought in at some point. Respondent states that the property line does pass through complainant's garage. Respondent states that he spoke to complainant one time regarding this complaint and told him he reset a corner of the property with a railroad spike as he could not get a long piece of rebar into the ground. An expert review was conducted, and it is the opinion of the expert that respondent committed no violations of the standard of practice, statutes, or rules governing this industry. The expert further explains that the complainant has contacted an attorney to help resolve this issue and has not provided an additional survey to back up this claim or any of the allegations in this complaint despite our requests. Therefore, counsel recommends dismissal.
Pretty straightforward. Again, we've got an expert reviewer with no violations. It looks like the complainant has started some legal action but has not provided an additional survey to back up their point of view. I don't see anything here. I agree with the recommendation from staff to dismiss.
In the form of a motion.
So moved.
Could I have a question?
Yes,
sir.
Wait, we have a motion first.
Got a
We need
second. Then you can ask
Second, then you
questions.
can talk about all your.
Okay, I'll second.
Okay.
Now, question. Would this be a case to monitor?
I think because an expert review was conducted, that I think no, not in my opinion. But I rely on your expertise as industry experts. So.
Just a question of curiosity. It seems like we have a common theme going today.
I
Everybody is on vacation.
As I'm reading these, because I did this quite a while ago, I'm thinking, did I copy and paste or something? Because this seems like everybody's got the same issues going on, but it definitely is not a mistake. It's just a coincidence.
I'm picking at you. Okay, we have a motion and a second. Any further discussion? All those in favor?
Aye.
Number 5, 2019-060-691. Complainant alleges that on or around June 30th, 2019, respondent and one other person came to the complainant's property to survey neighboring land. Counsel notes that complainant is not the client for whom the survey was completed. Complainant alleges that respondent and the respondent's partner identified themselves as state licensed land surveyors, but offers no proof or evidence of such allegation. Complainant alleges that respondent asked about boundary lines, and complainant told them that the boundary lines were as described in all current deeds. Complainant also told respondent about an existing survey, which complainant claims is incorrect and unregistered, which he communicated to respondent, supposedly, that respondent could consult but not use due to its alleged inaccuracies. Complainant further alleges that respondent used this alleged inaccurate survey to place inaccurate markers, changing the property line and allegedly taking away some of complainant's property. This complaint was sent for an investigation in order to obtain more information from the respondent and the respondent's employer, considering the employer has been an actively licensed land surveyor since 2001. The investigator spoke to the respondent and the respondent's employer, and both provided sworn affidavits to our office as well as the final stamped survey. Respondent's employer confirmed that respondent did the field work for the survey, and then the licensed employer reviewed and stamped the completed survey at issue. Respondent and the respondent's employer also confirmed they were hired by complainant's neighbor to complete the survey and to reference another survey done in 2016. The investigator spoke to the licensed surveyor who completed the 2016 survey, who confirmed that respondent had called him in reference to this 2016 survey, and it was discussed that there was no reason not to use the 2016 survey for the common property line. Internal research shows that respondent's license did expire December 31st, 2013, and has not been renewed. Respondent had been suspended for 6 months and required to take an additional 8-hour ethics course as a result of discipline imposed back in 2013, but never completed the renewal application process after the suspension expired. Considering there is no proof respondent identified himself as a licensed land surveyor and it is one person's word against another's, counsel recommends a letter of instruction, basically citing Tennessee Code annotated section 62-18-101, which states, quote, "It is unlawful for any person to practice or offer to practice land surveying in the state or to use in connection with the person's name or otherwise assume or advertise any title or description tending to convey the impression that the person is a land surveyor unless the person has been duly registered or exempted under this chapter."
Okay, first question, it says that they never did the renewal application process after the suspension expired. Well, I would have to assume from that statement that the respondent did complete the 8 hours ethics course in order to get his suspension removed. Usually we make that a condition thereof.
I want to verify that.
In my mind, the question here is the respondent employee of the surveyor that signed and sealed the survey that's in question here.
That specific, I don't have in the investigative report that specific question was asked, but my directions to the investigator were to verify that the processes were being followed, the procedures were being followed by a licensed land surveyor who's employing somebody who's not licensed. And so when I got the investigative report, there were no issues with that. So I can't say for sure that they are full-time employee, but I would think that would be a part of the report if they weren't.
I would hope so.
Right.
Because...
And that the respondent's employer would divulge that when they're giving us sworn statements about whether or not, they're following the statutes and rules.
Did the respondent's, the respondent's employer, did he stipulate in his sworn statement that respondent was a full-time employee?
Let me pull it up and see exactly what those words are.
She's looking that up. To me, on the face of what I've seen here, it looks like the respondent is a employee of another surveyor that went out acting as a crew chief.
I've got what you're speaking to right here.
Thank you.
Is that okay?
Yes, ma'am.
Sorry to interrupt. So the employer's affidavit is really short. Can I read it to you?
Yes, ma'am.
Okay. I am the surveyor with responsible charge for the survey of the property at issue. Respondent was the crew chief and the draftsman for the project. I approved all the work on this project and made the final decision. All artifacts used for the survey are attached to the responding email with the affidavit. That's the extent of it.
Now, for our edification, because we're not big in remembering the hierarchy of letters,
Yes, I understand.
give us the hierarchy of letters again.
Oh,
please.
as you mean like letter of instruction?
Yes.
Okay. So any kind of letter is going to be a private discipline, meaning it's not going to be exposed in a disciplinary action report that we publish on our website every month. It's going to be in the file for the licensee forever, I believe. Can anybody speak to that?
The letter of instruction, letter of warning, letter of instruction is just that. It's not considered discipline, but the letter of warning is.
Oh, okay, so it's not discipline at all.
Right, so letter of warning would be considered disciplinary. It's just it's not punitive in the sense that they're getting a fine attached to it or any further action. But the letter of instruction will go into will be a matter of record for us internally.
That's what I was.
So we would know if we instructed them, if anything happened in the future, this is something that the attorneys and staff can always look at, and we do. It's a very important piece of the information.
From the parenting world, the letter of instructions is kind of like being smacked on the wrist.
It is. And I thought a lot about this one, and I just felt it's it's one person's word against the other. If it came down to it, did I feel comfortable disciplining someone for something I didn't know that happened or not?
Well, let me say this. If I had been a surveyor up to 6 years ago, in my mind, I'm still a surveyor, even though I don't have that license. So if I happen to be on your property surveying and somebody says, "Are you a surveyor?" my response is probably going to be yes. Mm-hmm. Well, now, I didn't say that I was a licensed surveyor, but I said I was a surveyor because in my mind, that's who I have always been, even though I'm now no longer licensed. So that's the mindset that I get when I read this and even hear it as you read it, and you read it very good, is that this individual, had some pretty severe discipline placed on him.
Sir.
And that being as it is, that's been a while back.
Correct.
So, it's apparent that he's still in the industry. The respondent is still in the industry. So, in my mind, it would not be uncommon for him to say, if somebody asked him, he could say, "Yes, I'm a surveyor." Well, to John and Jane Q. Public, if I say I'm a surveyor, then the question of whether I'm licensed or not is kind of mute. In other words, it's just like if I asked you if you were an attorney and you said yes. Well, I didn't ask you if you were licensed in the state of Tennessee to practice, but you said you were an attorney, so now my mindset is you are an attorney. You are a professional, okay? And that's the same mindset I'm getting here from the surveyor. So that's why that I'm leaning a little harder towards a letter of warning as opposed to a letter of instruction.
I am amenable to making that amendment to my recommendation.
I really want to hear what Jay and Jackie
I do, yes. I
You're going to hear what I got to say.
Go ahead, Jay.
I almost take the opposite end here.
Okay.
I'm trying to just kind of put myself in the field and envision the confrontation, or the interaction, I should say, between the complainant and the field surveyors, and I choose those words carefully. And essentially what I envision is I'm going to see either himself or maybe 2 or 3 guys out there carrying an instrument over the shoulder, standard survey equipment, dressed appropriately, doing field work for a boundary survey. And being a layman or just a property owner that's not in the profession of surveying, as I don't know that they are, "Hey, look at those surveyors over there. What are y'all doing?" "No, we're surveying land over here." "Y'all surveyors?" "Yes, ma'am, we're surveying over here." They are surveyors.
Right.
With a small s, surveyors.
Right.
And they told us they were surveying.
And they told me we were surveyors. From what I'm reading here, he was a formerly licensed surveyor, but that's not the issue here. They're just surveyors with an S, because they got they're doing surveys.
Right.
From what I'm reading here, there's no inappropriate work here being done. They were working under a current and valid licensed surveyor, doing the field work authorized and supervised by a valid licensed surveyor. It's like me sending out my field crew. It's like me sending out my surveyors to go do some work with a small s, surveyors. That's where I'm after. So the respondent, if I understand this correctly, the respondent we're talking about is the gentleman that was in the field performing the survey work, who used to be a licensed surveyor, but not currently licensed capital surveyor, but just performing survey work under a licensed surveyor. Nothing wrong there. Nothing wrong there. What did he do wrong? Now, unless in the interaction out in the field he goes, "Yeah, I'm a professional surveyor," or "Yes, I'm professional surveyor, license number, blah blah blah." Now we got an issue. And again, it's worded. It's he said, she said.
Mm-hmm.
which is kind of why I thought, if we do a letter of instruction, my plan was to clearly instruct that, not accuse, but instruct when you're in the field, you can't use any kind of language that would indicate that you are a licensed surveyor. And really emphasize those things, not accuse the person of that they did it. But now the burden is on them in the future. If it happens again, we've told them exactly what to do. We've cleared that gray area up.
Okay, so to argue my own point here,
First of all, before you start that, I want to say I agree with what you're saying with one caveat. The complainant, who is an unlicensed surveyor, has to be a full-time employee of the licensed surveyor that is in ultimate responsible charge. If he can't be a subcontractor, he has to be an employee.
I'm not disagreeing with you, but it's another issue. It's another issue. Let me stick with my point here, and we can get back to that. Now, to counteract my own argument here, in the first paragraph, it states here, and his partner identified themselves as state licensed land surveyors. That's not in quotes, however.
Exactly. It's a complete allegation.
So
That's just what the complainant alleges.
now, if that were in quotes, I would have an issue. I would have an issue.
Her typewriter was broke that day.
No, I did not put.
I mean, what I'm saying is, if in the encounter in the field is, hey, y'all surveyors? Yes, ma'am. I'm a state licensed land. That's one thing.
I find that hard to believe that that's what occurred.
Yeah, and I do as well. So, with that in mind,
Now, if it was the
outside
client, I think maybe I believe it. But this is somebody who's mad about what happened.
Right. I don't know. I don't see that the respondent, which is who we're dealing with here, has done anything wrong. I just don't see it. If it was just an encounter, yes, ma'am, we're surveyors and we're surveying this land, I don't have an issue with that.
Therefore, I think the letter of instruction is the best route to go, because we're telling him, just giving him a reminder, don't present yourself as a licensed surveyor.
I'm going to cite everything that I can possibly cite in that letter, because there's other things that go with.
Right. The only thing that really consoles me in my argument is that the fact that a letter of instruction is not a disciplinary issue. It is literally just a letter that goes in the file. Correct me if I say something wrong here. A letter that goes in the file just saying, hey, by the way, remember such and such. And that I'm comfortable with. I just don't want to shortchange this guy that's thinking that we think he did anything wrong. I don't think he did anything wrong. I just don't see it here.
Well, and actually, believe it or not, Jay, I agree with you and Jackie. The purpose of the exercise was to make sure that we were sending the right letter.
Yes, sir.
But I agree with the conversation wholeheartedly, and that's why that I broached it in the way that I did, so that we would get that conversation. So we got exactly what I was looking for.
Great. I'm glad.
Yeah.
I could follow up on that if I could just say that, for other surveyors out there that are listening, watching, whatever the case may be, if you got a minute on the tailgate with your field crews, you may want to just, hey, by the way, if somebody ever asks you, are you a surveyor, just help me out and just say, yeah, we're a survey crew, or something to that effect.
Yeah.
Just
Or I
to
work
avoid
for
something
one or
similar
whatever,
like
yeah.
this in the
Yeah.
future. Again, I'm not saying that the respondent did anything wrong here. I don't believe he did, but perhaps a letter of instruction in his file, I don't think is like I said, not disciplinary. I don't think it does any harm. It certainly does a reminder to him, and it doesn't make me think anything less of him, but certainly may be proactive towards other surveyors out there.
And as Jackie said, it's important, just for you from the legal side of it, it's important to know what that real relationship is between the respondent and his employer.
Yes, sir.
As far as the license goes.
Thank you.
Because
I understand.
that's something that I think we take a little dim view of, is this, I'm going to call it subcontract world.
Okay.
And leave it at that, I guess.
That's very helpful to me.
I think there's
Thank you.
language somewhere, I think, I can't quote it or go to it, that says
It does.
To subcontract unlicensed professional.
Right.
Something to that effect.
But is there any more discussion at this time? If not, we'll entertain a motion.
I'm move that we accept the recommendation for a letter of instruction, citing Tennessee Code annotated 62-18-101.
Second.
Okay, we have a motion and a second. Anything else? If not, all those in favor?
Aye.
Okay. You're batting 1,000. Miss Erica.
All right, number 6, 2019-069671. Complainant is involved in a boundary dispute in civil court with a neighbor. Again, common. Counsel notes that complainant is not the client for whom the survey at issue was completed. Complainant claims respondent sold the land survey to his neighbor in 2017, but notes that respondent's license... Of course.
Is that word sold correct right there?
Yeah, I was confused on that as well. I'm like, what?
That's the word that was used by the complainant.
I just doubted it, and that's fine. If it is, it doesn't flow with the sentence.
Okay. Well, now I feel like I sold the land survey. Hold on. Can I have one moment, please?
$10, I'll give you a copy. Is that what he said? Really? Yeah.
Well, the question it brings to my mind, was a survey done,
For both parties.
no, or sometime prior to 2017, say,
Yeah.
make a date up, 2010, and he turned around and sold it to the new client in 2017.
That doesn't say that.
That's that's the complaint says in short, respondent sold a land survey to my neighbor in 2017. Those are the exact words.
That's a separate violation.
So, okay. So
We'll
talk about it. Okay. So I'll read that sentence one more time. Complainant claims respondent sold the land survey to his neighbor in 2017, but notes that respondent's license has been expired since 2015. Complainant argues that the fact respondent's license has been expired should negate the legitimacy of respondent's survey being put forth as evidence in the civil case, but takes issue because the judge has not thrown it out. Complainant's civil attorney advised her to file this complaint as a result, but counsel opines that this specific issue is not one for the board to consider, as it is currently being litigated, and all documentation regarding respondent's license history has been provided to complainant's attorney in response to a public records request. And I just want to clarify what I mean by that. I don't think it is the sole issue of whether or not the survey is a valid survey to be looked at in the eyes of the court is not an issue for us to consider today. That is the only thing that I am saying. Everything else I think is a very valid issue. Respondent's license has been expired since December 31st, 2015. Respondent appeared before the board in July of 2018 to try to renew his license and made it known to the board at that meeting that he had just recently discovered that his license had expired, despite it having expired 2.5 years prior. Respondent told the board that he had kept current with all continuing education and that his renewal application and documentation had been submitted. However, all required information and documentation was not timely submitted to the board by respondent. Due to the length of time that respondent had been expired, he appeared in front of the board requesting that it waive the examination request for his license to be reinstated. This request was denied, and respondent was advised of what was necessary to complete his application to renew his license after appearing in front of the board, but has failed to renew the license to date. Tennessee Code annotated section 62-18-113 states that, quote, "It is the sole responsibility of any person registered as a land surveyor to renew the person's registration on or before the date of its expiration," end quote. Additionally, Tennessee Code annotated section 62-18-101 speaks to unlicensed activity of a land surveyor, anyone that does not have a license in Tennessee. This complaint was sent for investigation and for an expert review. The investigator spoke to the respondent and obtained a sworn affidavit. Respondent states that he is aware his license is still expired and that he is currently not advertising in any way to be a licensed land surveyor. Respondent states that he is unsure of how many surveys he completed prior to finding out his license was expired and before appearing before the board in 2018. Respondent states that while he does keep copies of all his surveys, he was recently seriously injured, is unable to access them. However, respondent states that he has not completed any surveys since finding out his license was expired and since appearing before the board in 2018. The survey at issue in this complaint was completed in 2017 after the respondent's license had expired, but before he appeared in front of the board in July of 2018, as stated in the paragraph above, or that I just spoke to. This complaint was also sent out for an expert review, and it is the opinion of the expert reviewer that respondent's survey contained the following violations. Standards of Practice Chapter Rule 0820-031B1. The survey lacked a descriptive location or vicinity or corner tie indicating point of beginning. Standards 0820-031B7. The ratio of precision of the unadjusted survey is not shown. Standards of Practice Rule 0820-031H3. The size and type of the property corners are not indicated. And then the respondent was not licensed at the time, or I'm sorry, had an expired license, so therefore violated Tennessee Code Annotated Section 62-18101 and 62-18113 by failing to renew the license and therefore committing unauthorized practice as a land surveyor. My recommendation is assessing a $1,000 penalty, which is the maximum penalty we can assess for each of the 4 violations, for a total of a $4,000 civil penalty. I know this might be confusing, so please ask as many questions as you want, because I've reviewed this many times and I can probably answer anything you have about, if you're confused about what happened before the respondent appeared before the board and after, and how that all worked out, because I know it is very confusing.
First question I have is, the investigator obtained a sworn affidavit and that the respondent states that he's aware his license is still expired and he is not currently advertising in any way to be a licensed surveyor. Did the Google his name to see if it came up as a licensed surveyor?
I have not. I don't know if the investigator did, but the investigator also stated in the report that, and I think this verbatim, there's no evidence of any unlicensed activity by respondent. So I would hope that they would have Googled.
My greater concern, Erica, is I was very uncomfortable how we handled these individuals in this, I'm going to say, niche of non-renewal, and we had several of those.
But okay.
When this gentleman appeared, there were several at that time. I was concerned about the precedent that we were setting at that time. Now we have a case against one of those same individuals that we basically, I'm going to say in my poor lingo, turned a blind eye to what they had done from the date they appeared right there in front of us back to when their license actually expired. Now we have an individual that has done that scenario, and there is a complaint on work that was done within that same window. And I'm really concerned where we go from here with that, because it kind of hits me, as the old saying at home is, we're talking out of both sides of our mouth. And I'm really, really concerned about that. Because, I mean, I know how to handle this face up, but I think we've got this gorilla in the room that we've already spoke to, and I don't know how that gorilla goes away so that we can address this. And I don't know what the other members think, but that's really from the heart of where I'm concerned.
And correct me if I'm wrong, if I'm not hearing the point you're trying to get across, but my kind of plan, because I thought about that, was to separate the two issues of being expired at that time when the respondent came and appeared before you, and that was the only reason that the respondent was appearing. It was not for any kind of complaint or allegations of violations or any survey. And that was dealt with. The respondent was clearly advised, and we have record of it, of what needed to be done to get that license renewed. That is a totally separate issue from what I feel like the violations are here in a survey that was done before that respondent ever appeared before you on a totally different issue. Does that help? I feel like what we're punishing the respondent, what we would be punishing the respondent for here, is simply violations in a survey that he completed in 2017, and for not being licensed while that survey was completed, well before that he ever appeared in front of you and got any kind of advice or instruction. Does that make sense?
Yeah, I agree with what you're saying there exactly, and I think you said it better than I could have. When the respondent appeared before us, they were trying to find the path to renew their license. I think they were trying to gain a path to renew without having to take the reexamination.
Correct.
And that was the issue, and that was the issue only. It had nothing to do with any surveys that he may or may not have performed while not licensed. Had nothing to do with that. There was no complaint filed at the time. We may have been somewhat aware that perhaps he was performing surveys during that time, but we did not have a complaint. Now we do. Now we do, and how are we going to address it? I'll tell you how we're going to address it.
Well, now,
how I want to address it.
Before we address it, let's stay on this merit of where we've been.
Okay.
Let's clean up the tracks through the woods, okay? There were a couple of these that we did file a board complaint on. And if I'm not mistaken, I thought we did it on all of them to be consistent. And your disciplinary history for this case speaks to a 2018 letter of warning. What does that letter say?
And we've got that in the file, so just give me one moment. We'll pull that up. Where should I look?
That may very well,
I don't want to put us in a box.
as we did, I remember the same thing in that I thought everyone that had expired, we would open a board complaint against. And I would assume that this history is from that complaint, he was given a letter of warning.
It may be, but I want to have our greatest goal here, this is for you, Miss Jennifer, our greatest goal is a huge level of consistency.
Got to be.
So if we have problem A, we respond with B, whatever it is, every time. And that's why that I'm wanting to beat this drum a little bit. Go ahead, Miss Erica.
Okay. So the board did open an administrative complaint, and that is what resulted in the letter of warning, and the letter of warning cited unlicensed activity. And that was that letter was sent on October 29th, 2018.
Okay, now I'm getting ready for Jay. Having went through that exercise, is it your opinion as counsel for us in this matter that we can move forward with this on its own merit based on where we've been? That's my number one question. Okay, thank you.
I'm very confident.
Thank you very much, Jay. You got it.
Okay. So with that in mind, what I'm seeing here is basically the unlicensed surveyor has been caught, is essentially what happened, by a client of theirs while he was unlicensed performing surveys. And it
Not
appears...
a client of theirs. I think it's the neighbor, isn't it?
Of the neighbors. Yeah, the neighbors. That's right. Excuse me.
Correct.
And it appears that, from what I'm reading here, that perhaps the expert reviewer, and please confirm this for me, got a copy of the survey or got the survey and was able to review the survey.
Correct.
Okay, and from the expert reviewer's findings, they had 4 findings, 3 of which I consider to be somewhat minor in terms of the big picture, but not irrelevant by any means, but still a violation. And those were outlined as being the vicinity or corner tie, the ratio of precision, and the size and type of property corners. All clear indications of violations of our standards to the same standards that we hold future applicants on their example plats, exactly the same standards. The 4th one is where I find certainly the most interest, and this is where the unlicensed surveyor at the time is essentially caught with the failure to renew the license, unauthorized practice as a surveyor, signing, stamping a survey dated and performed while not licensed, which is obviously what I consider more of a major violation. I do want to ask the question of counsel that in no way did we, based on this letter of warning that's in the file, and from his presentation where we considered his potential future application, perhaps dismissing a state-specific exam, in no way did we, again this is a question, did we dismiss any of the activities that he performed while unlicensed, whether he knew it or not, because it's his responsibility, their responsibility, sole responsibility, thank you. In no way did we dismiss any of those actions based on our standards of practice for any surveys performed during that window of unlicensed activity.
What do you mean by dismissed?
That the letter of warning in this file covered the disciplinary action by this board for all surveys conducted during that time. In other words, are we trying the same case twice, is what I'm saying.
Okay. I see. Okay.
Yeah. In other words, have we already taken action
On the unlicensed part?
on the unlicensed
By
part?
sending the letter?
By sending the letter.
Okay. I'm going to read it
Certainly.
because I didn't write it.
And
so-
I'm only addressing the fourth item, not the
It's
other.
very good, very valid. I'm glad you brought that up. I'm glad you brought that up because after reading it, I think there's a very good argument to be made that we could be trying to discipline for unlicensed activity twice.
My non-legal
Yes.
opinion, I think I would agree with that.
Can I ask a question?
Yes.
Can you specifically say what the letter of warning, the language was?
Stuart, can I?
I thought you just read it.
No, I read it privately.
I thought that's what you said out loud a minute ago.
I don't know if it's a public record or not, but it's private to his file or
It's
not.
Reading-
not public record.
It's not public. Okay.
Reading no, I haven't read the letter of warning.
Oh.
No, I didn't read that to you. I read it privately.
Okay.
So no, I can't read it. I can say what it's citing.
Come on, Stuart. You've been so quiet.
This is one time, right?
Now you're being difficult, Stuart.
I don't want to do anything wrong here. Why does it cite?
Just the board is aware that unlicensed activity has been going on from the time that the grace renewal period, I guess, expired until the time the letter was sent, basically. Cautioning, that's not okay.
So I don't know how that's
thought we did
an
deliver-
indictment or an action for unlicensed survey.
Well,
I thought we did a civil penalty with that too.
no,
We didn't?
no.
I know we discussed it.
Definitely no civil penalty that I see. But so that makes me think we educated the respondent via letter of warning about how serious unlicensed activity, how serious of a violation it is, and when he was committing those violations, and that he would be continuing to commit them. But it was based on a board complaint. It was not based on this complaint about a specific survey. So
See,
we had, it's
the
kind of
respondent
vague.
stood right
Can I
there.
say one more thing?
Go ahead, yeah.
A letter of warning is not formal disciplinary action. So if there was not a civil penalty involved, then there's really not been disciplinary action taken against this respondent.
There's definitely not been any taken against this respondent as a result of this survey.
Go ahead, Jay.
No, the way I would look at it, that when we sent the letter of warning, we're saying, hey, the board recognizes and is making you aware, if you're not already, that during this time, until your license are renewed, which still hasn't been done,
Right.
you can't practice surveying, basically. We wasn't addressing a specific case. It was just be aware, and if any cases come before, then we'll have to, that will come into play, in my opinion.
In other words, it's a general warning. It's just a broad warning. Hey, we see
Exactly.
we see what you're doing. Just you need to stop it or get in line and comply.
This is the first matter that I can say in the 10 years that I've sat on this board that have this notion that we could be sued over.
I understand completely. I will say, what I'm recommending is an offer of a settlement. The respondent has every right to come back with a counteroffer with maybe, I'm just throwing this out there, it's a total hypothetical, but, I agree I committed these 3 violations, but the unlicensed activity could argue that, and I can come back and represent that counteroffer to you and why, and many mitigating factors, or the respondent can say, I want a hearing, and then we get to put it all out there, and you get to hear everything. This is not a definitive, deciding factor on the discipline. So there's that. There's the opportunity for the respondent to talk to me about what they feel is just and not. And then we can discuss further.
I find it interesting that there's a statement in here that says respondent states that he does keep his records, but he's seriously injured and unable to access them. Well, when he was physically able to be here and stand erect at that podium right there, and I looked him straight in the eye and I said, how many surveys have you completed? And he said, I have no idea. That was his response, and that should be a public record.
Right.
So,
And that's still the response.
yeah, I mean, I'm going to go back. Let's go back to point. The word sold in the 3rd sentence tells me that this respondent violated 0820-04-.05 subparagraph 3. And that has nothing to do with the unlicensed part.
Which one?
It's in rules of professional conduct.
I'm sorry. 045.
Professional conduct. I don't know where it fits in our civil penalty chart. However, I am going to say that I do have a question about civil penalties. It says under 0821-.06, subparagraph 3, in determining the amount of any civil penalty to be assessed pursuant to this rule, the board may consider the following factors. Now, my question when I say that is, can the board exceed, other than a multiplier of days, any of those amounts? Is my question. Because all those amounts are keyed to number of days.
Oh, Stuart, I don't think so.
I think that's probably the answer, but I'm just asking the question.
I don't think so.
Okay.
And then as far as the allegation of selling, that, and that's probably my fault for not emphasizing that as being a problem to the investigator, but it really wasn't discussed, I don't believe, by the investigator or the expert. So that's simply an allegation at this point and not been spoken to by the respondent. So I just want to make sure that that's clear. It's not a fact, just an allegation that has not really been investigated further.
Which did you cite? I want to read it.
It's
Oh, but which?
0820, 04, 05, paragraph 3.
Here's the one thing I thought it was.
That's where you work for 2 clients at the same time.
But it says, it doesn't say that it's not permissible, that it says it's not acceptable unless the circumstances are fully disclosed and are agreed to in writing. That we don't know. We don't know whether that's been.
Right, I just wanted to make that clear, that we don't know.
But as it says in standard practice, the drawing, plat, map, etc., is the intellectual property of the surveyor, but it's whatever the contractual relationship with the client is. So technically, it's the person that paid for it, that's who it belongs to, basically.
Right, of course.
So if if I did a survey for you, it's not my purview to sell it to Jackie.
Without making her aware of it.
Without making you
Unless
aware of it.
right.
I can do it, but you've got to agree to it.
Right,
Okay?
right.
And I don't know, and you're fair in what you're saying. We don't know if there was any kind of agreement or arrangement or whatever, but that's clearly, I'm just pointing out,
No, I
that is
appreciate
clearly
that.
a professional conduct violation,
Correct.
if that is a fact.
Right, right.
If it's supposition, then it's not a violation.
Do you think there's any chance the complainant could have meant that they hired a surveyor and paid them to do something, and used the word sold? Because I didn't think about it that way, and I'm glad you brought it to my attention, and that's how I thought about it, is that they're just, I read complaints all the time where maybe it's hard to describe what you're trying to say.
We have requests reasonably often if we're surveying for client A and it adjoins client B, it's not too uncommon for client B to say, can I get a copy of their survey?
And then you need to ask the client.
Right, and then you go through
I
the
see.
process.
Okay, so that's, I guess, what I was
That
saying.
is not an uncommon question to be asked.
So then that's
It's not
something that
regular,
can
it's not
be-
every job.
It's definitely something that can be investigated further
Yeah.
if we decide to defer this.
Chairman, it looks like we need more information then on this one. Do you want to represent this one at the next meeting? Is that where we're going with this?
Well, we still have all the other, I don't want to forget about the other.
Issue of
things.
sold, yeah, I think we need more information.
Okay.
But there's still, that's just a minor piece. We
That's,
still
that's
got
a
the-
small piece of the puzzle.
Yeah, that's just something added in there.
I think, again, I think the gorilla in the room is relative to what we have done versus what we can do now. I feel like that's the gorilla.
Okay, I'm sorry. The gorilla is,
What we did with the letter of warning versus what we're being potentially asked as to deal with council's recommendation.
So since we're on the record, and so because we can't read the letter of warning on the record, perhaps we could defer this to the next session, but let's give some specific questions to legal that you have for legal. One would certainly be the if it's sold, or if perhaps the investigation is going to show that the inmate performed and not sold. But also, that way it gives legal time to be able to speak and preserve some confidentiality on the issue as to whether that issue was resolved by him appearing in 2008, or if the issue was specific to him not renewing and did not waive any further assessment of fines or penalties in the future. So I think perhaps we need to give legal a little bit of time to review those things, give them some specific questions, and defer this one.
Yeah, I definitely agree with you, because there is definitely a hole here that needs to be filled with that question, and I don't want to take the wrong action without getting that information. And what is time? Time doesn't hurt us here. Time doesn't hurt us here. To the next meeting is fine. Although the first three items I think are pretty cut and dry.
yes.
I think are pretty cut and dry.
I agree.
And I would be comfortable with taking action on that today.
Oh, yeah.
However, if council suggests that, look, let's just lump it all in one thing and just carry it all forward, I'm fine with that for 3 months. I'm fine with that.
One thing I do want to ask, because I am so new to this, and in the spirit of consistency, what I don't know is if you take these separate violations without the history and without what appears to be an egregious situation, if you just take those individually, is $1,000 penalty on those specific things standard, or is that in the totality of the circumstances that those things now become $1,000? So we may need to do some more investigation before we assess those penalties to those specific violations.
It sounds like it was spoke by an attorney.
I was thinking the same
Because it
thing.
was so well said.
I tell you.
But no, you're exactly right. And I will throw this barb out. I threw it out to Glenn earlier. This one hits the high water mark of an executive session issue. But we currently don't do those, but it does hit that high water mark, because I think we could kind of all bang our heads against the wall in an executive session and come out with a resolve. But we're not going there, because Stuart's here and he's the enforcer, so we don't want to mess that up.
So we can likely just defer. Do we need a motion to defer to the next?
Do we have a motion?
Yeah, I would move that we defer it and allow council time to review the issue there. Second.
Okay, we have a motion and a second, and Miss Erica, I would like to include the fact that sold be investigated.
Oh, absolutely. I'm going to do a completely new investigative report, or request.
Okay.
And we're going to look into that, and I will have an answer for you.
I think that has some value to this particular case if it has merit.
Absolutely.
Okay. All right, we have a motion and a second to defer the legal report item number 6, 2019-069671, until our next meeting, or until legal has proper information to provide for us. Is that fair?
That's fair.
Okay. All those in favor?
Aye.
Okay. All right.
Okay, this brings us to the last one.
Well, that goes down as a tie, so you're still perfect. You're ready.
Oh, okay, good. Oh, now I'm nervous. Okay, 2019-063091. Complainant alleges that after having issues getting in touch with the original surveyor of her property, she reached out to respondent and he agreed to meet and discuss separating some acreage for complainant and doing a boundary and division survey. Complainant alleges that she paid respondent half of the fee, with the rest to be paid upon receipt of the completed survey. Complainant further alleges that respondent approached her after the initial meeting and requested more money, so complainant paid the entire fee at that time without a completed survey. Approximately 1 month later, complainant alleges that respondent provided her with an incomplete and inaccurate survey. Complainant further alleges that several months subsequent to receiving the survey, she attempted to contact respondent and attempted to address the alleged inaccuracies in the incomplete survey. Complainant states that after threatening respondent with a board complaint, respondent came back and walked the property again. Complainant alleges that respondent acknowledged the mistake but stated that it was, quote, on paper only, unquote, and promised to correct the survey. Complainant also alleges that it is well known that respondent has a drug problem that has been affecting the way he conducts business. Therefore, I sent this complaint out for investigation because the respondent had not responded to the complaint. And despite every effort by our office, as well as our investigator, we weren't able to get a response. The complaint was also sent out for an expert review, but counsel notes that the expert was unable to consider any defense respondent may have offered considering the lack of any response, and was only able to consider the complaint's allegations and documentation provided by the complainant. So based solely on the complainant's allegations and documentation provided, it is the opinion of the expert reviewer that the respondent is in violation of Standards of Practice Rule 0820-04-.021, which states, quote, the registrant shall at all times recognize the primary obligation to protect the safety, health, and welfare of the public in the performance of the registrant's professional duties. And then also a violation of the Standards of Practice Rule 0820-04-.023, which states, quote, the registrant shall respond to all inquiries and correspondence from the board within 15 days from the day of receipt and shall timely claim undelivered correspondence from the U.S. Postal Service or any other delivery service upon notice thereof. The expert considered the fact that it seems complainant has been led on by respondent for many months after payment and was made in full, complainant's implications that respondent has been incompetent and unprofessional, and complainant's suggestion that respondent may have a drug problem. The expert was reluctant to list a clear violation of 0820-04-0.021, which speaks to the safety of the public. The general safety, health, and welfare of the public. But, however, the expert and counsel find a clear violation of 0820-04-.023, which is failure to respond to the board because of respondent's failure to respond to this complaint. Therefore, so after I submitted this report, I got the investigative report back. I had already gotten the expert review back, but the investigator had gotten an updated phone number from complainant for the respondent, and when the investigator tried that phone number, very recently, it had already been disconnected, and the investigator made it really clear in the report that he did everything he knew to contact this respondent. Also going to the respondent's house that we know of, the address provided, taking pictures of the mailbox, knocking on the door, leaving his business card, asking for a response. So that's as far as I know that we can take it. This case bothered me, though, obviously, for the obvious reasons. We don't know where the respondent is. We don't know what the respondent's doing. The respondent is active through the end of the year, I believe. Yeah, through December 31st, which makes this even more important in my opinion. But my recommendation was a $1,000 civil penalty for failure to respond, plus the requirement to complete an ethics course above and beyond what a surveyor would be responsible for. But then I understand we have the issue of finding the respondent, if that's what's voted on. So I really would like to discuss this also.
Okay. First off, if I may, I would like to correct the expert reviewer because the section cited are from the rules of professional conduct, not from the standards of practice.
Okay.
So that should be changed along with your recommendation, the rules of conduct. And I'll repeat, as I always say, probably the worst thing that a licensee or a respondent can do in regards to this board is not respond, as far as I'm concerned.
I agree.
For whatever reason.
I agree completely.
I mean, unless they're dead, they need to respond, in my opinion, period.
I agree.
And that's obvious that's not happened. And I looked at the fact that this respondent renews at the end of the year, and with process being what process is, if we make a decision, the respondent's probably not even going to really hear about it per se till after Thanksgiving, per se. Now, it may be quicker than that, but then they've got a response period.
Right, 30 days.
They've got another 30 days after that. So they're technically not even going to hear until probably their license is ready for full renewal, or it expires, one or the other.
Which is what I was thinking, we can think about, this can be flagged to see what happens with that, where it goes. If we can.
I mean, it sounds like to me that.
On top of what I'm recommending,
That your investigator and you all have made every conscious effort that you can think of or try to find this individual. I don't know what.
I'm confident in saying yes.
I don't know what the reason why this individual is not accessible, let's put it that way. But I guess one question that I have is, when an individual does not respond in the period that you allow, which I guess is 30 days.
Unless cited otherwise.
Right.
When
they don't respond, is this board able to increase the assessment of a penalty, or does that simple response simply fall under a particular civil category that says it can only be $1,000?
Well, to answer that question, let's see. So TCA 6218-116A1C. Read that. States that the board may refuse to issue, basically the board can discipline a licensee for any violation of this chapter or of any rules duly adopted under this chapter. So the failure to respond is a violation of a rule, so that allows us to discipline. And then A1C allows for a $50 to $1,000 civil penalty. I guess we could argue that it could be every day that the respondent's not responded.
It says every day of continued violation shall constitute a separate violation. Right. That's where I'm coming from.
Right. So yes, that can. I mean,
it's my notion. If the 30th, the day ended September 30, for example, and we're here reviewing this, well, they're already 24 days late.
Right.
That's 24 times 1,000.
Right.
Until you write from to then. So, in my opinion, that penalty should be, in my example, $24,000.
So calculated to the days.
Yes.
I guess from the time, the deadline to respond to today, we can calculate it, multiply that by 1,000. That might get the respondent's attention.
Well, you don't know that. I start saying until he responds, it keeps growing.
I think we could do that, right? Could word it that way, but well, Stuart, do you have any concerns?
I think they have 15 days to respond on any inquiry, so I would suggest that maybe it's a 15-day thing, because if it's ongoing, it could go way high.
Well, yeah, it could, and that's the point. I mean, the 15-day window he's not penalized for. It's that 16th day and beyond. Right, then he is in violation of the one we're discussing here. So, are we 24 day or whatever?
Yeah,
I don't know. I don't know the exact dates
you
here,
could go each day.
Yeah.
And I think that's what we're asking.
And I think we should.
And I think we can. I think the rules allow it.
Yeah.
The rules do allow each day up to $1,000 of any violation.
See, in my opinion, if we can do that, then I think we make a decision on this and we move forward, and we've got teeth.
And that's just, that's something I think that if we can get the respondent to talk to us, I think that is definitely showing how seriously we take this. And it can be discussed further if I get in touch with the respondent, and it can be brought back, or it can be, reduced if there were mitigating factors.
Right.
This is not a final decision,
I can speak from experience on this board of another occasion that I indicated a huge civil penalty and was voted down on it. But I made a statement at the end of the civil penalty when it was determined what it was. I said, it was an unlicensee. I said, the unlicensee will pay that within 2 weeks and we'll be right back doing what they were doing. And that's exactly what they did. They didn't bat an eye, and they're still out there doing it. And we've had surveyors in here complaining about that same person more than one occasion. So, it's my notion that that these rules were put in here with that multiplier for a reason, and it's not something we should use all the time, but there's certain times that we should use it. And this case leads to me that it needs to be used, because if it's got enough teeth in it, this guy's going to show up, or lady, or whoever it is.
Right. No, I will ask that we come up with a definitive multiplier, because when I send the offer out, it has to be a definitive amount. It can't be open-ended.
Well, all you need to tell us is when was day 16.
So, or I can just say, can I multiply it from day 16 to today?
Yes.
And we'll do times 1,000.
That's it.
Yes,
And that's
times
the
1,000.
amended recommendation.
Right.
Okay. Plus, do we want to do the ethics course on top of that? Okay.
Yes.
And I'm not going to go where I was going to go. I was going to also ask for a suspension of 6 months of the license as well. But
I thought y'all could deal with that if the renewal ever comes up, because this discipline can be taken.
Do we have, that is a good question, good point, Erica. Do we have the ability to deny/delay a renewal because of outstanding?
Absolutely. Oh, yes. Because, the statute I just read you can deny, revoke, suspend for any violation of any rule or statute. So, absolutely.
Well, if we've got a heavy hitter out here on a civil penalty and it's not performed, then we're not renewing, no matter how
Absolutely
many
not.
checks or whatever it sends in.
Right?
Right? Wrong? Okay, good.
So we have a default status in our database when somebody is not complying, right? Anybody? We do. I know we do.
Okay.
As for payment, we'll get that when we get to the budget, but you can actually see some of the numbers on that and on who complies, the case revenue. We just typically will run a report periodically and then evaluate that through those channels. Legal does track that. We can pull that. The system will allow that option.
I was just thinking, should we flag it? Because I just want to make sure if, let's say we send this out, can't get in touch with the respondent, but somehow the respondent renews or tries to renew online, and if this hasn't been signed, it's not going to be a discipline. So I just want to make sure that any kind of renewal application can come to us, to legal, just so we make sure that it's brought to.
Stuart, what makes a discipline formal when it is not acknowledged as received by the respondent?
Well, if it's not received, it comes back unclaimed, then proper service hasn't been made. So then we could not move forward to a formal hearing.
So it's the same as discipline never happened, per se.
Exactly. So basically, you have to have some type of proper service on the respondent in order to move forward with a formal disciplinary action.
Well, see, what I hear,
Sorry.
what I hear you saying is that if we go through all this effort and Erica sends all this out, and this registrant or respondent does not take notice of it, and then the last week of December sends his stuff in to Miss Jamie, she renews him, then he defeated the whole process.
There's other ways to get proper service. I mean, and if we can prove that he's refusing it or anything like that, I mean, we can have personal service on the respondent. We do that all the time with ones that we can't, that come back unclaimed or.
There's service by publication as well, is that?
Right, and there is service by publication. So there are ways to get around it. I mean, and it's just the unclaimed part is always the tough one.
I understand that that's a football that you got to kick around and figure out how to deal with it. But my concern is because of the window that we're in less than about a 60-day window for renewal. And, it takes you all a certain amount of time to do your process, do your thing, so forth and so on. Then they have a certain amount of time to either be served, respond, etc. I don't want to get to the point to where what I just said happens.
I don't either. So we definitely have to, I don't know if the commission needs to vote on anything regarding that, but I'm not going to let this, after this meeting, we can meet together and make sure we come up with a way that nothing falls through the cracks here when it comes to any kind of renewal that might come in if I haven't been able to contact the respondent or obtain service or anything like that before the end of the year.
One thing, just from an administrative standpoint, as far as flagging, it's a lot easier with this board than it is with some others because they renew at the same time.
Right.
So that makes it a lot easier because we'll get all those folks at once, and we can put a note on the front screen of their license. So when we pull that, they'll be notified. But we can, and then I was about to say it's a small group. We're looking at right around a little over 1,000, but it's not that small, but enough where since we're getting all at once, and we can run reports and spreads and capture that. It's not that difficult. We can.
Correct me if I'm wrong here, but I think the whole purpose of what you're saying is he or she goes to gets renewed because there's no formal disciplinary action, but there's still that complaint is still open. So that I think that's our avenue, not to renew because he has an open complaint against him that hasn't been addressed.
I don't know if that's the flag or not.
On their renewal as well, they have character questions that they have to answer in regards to disciplinary action and the like. So that could become a separate issue depending on how they answer that.
Not to mention they have to give us their address and their phone number and their email so I can contact them.
Nobody ever lies?
Oh yeah, then we can discipline them for
Maybe.
that.
Another issue you got to think about is they have 30 days to answer once they're served or once they receive whatever action you take. So really your window is a little shorter.
And renewals will be available the beginning of November.
I will say as long as I can get approval from my higher ups, if this is approved, or if any kind of discipline is approved, I'm going to mail it, email it, but I'm also going to immediately try to personally serve it. Just to cover all the basis, considering the discussions we've had. Usually we don't do that, but I'm going to do it on the front end.
Well, we've got a new renewal system. It's all, we're on new ground again this year. The last 2 or 3, we've been on new ground every time. So we're on new ground this round. It's an audit and so forth and so on.
Right. You're talking about the auto renewals. Yeah. But there's workarounds to flag that and to capture that at the gate. So there's.
I mean, just from my purview, I think that it would be good to know for this board to know that we have a system in place for any disciplinary action or any let's say any deficiency that a licensee has that's open, that their renewal be flagged. Such that somebody has got to look at it. It just doesn't happen.
The capability is definitely there.
Okay. Well, that's great. I mean, because I think that's reassuring to this board that we have that mechanism, because, it becomes pointless or fruitless for us to go through all this deliberation and then somebody sneaks under the radar and keeps right on moving.
So we can amend the recommendation to also flag the complaint with the capabilities that Glenn just referenced.
So the recommendation now, if, I'm going to just pitch this out and we'll discuss whether we're going to have a motion or not. But the recommendation would be a $1,000 civil penalty per day starting from the first day after the official notification period to this respondent. Multiplier, basically.
Right, through today.
Through today, through the day this board meeting. And the completion of an 8 hours ethic course above and beyond what is normally required for licensed surveyors within 180 days of the, I guess, with the consent order or whatever the document is. But my notion is, once you put that multiplier on there, this individual's gone. They won't.
They're not already.
They won't perform. They won't perform. They won't perform. I mean, seriously, I'm going to just throw this out, and Jay and Jackie can disagree, but probably for the average surveyor, if a civil penalty exceeds $10,000, chances are they're probably not going to pay it, especially if they're in any particular point in time in their career that either they're doing something different than day-to-day land surveying, or they're maybe close to retirement or something of that nature. Now, that's just a total supposition on my part, but I wouldn't be surprised if it was more factual.
And you want to add?
And to flag.
The legal will flag the file.
Flag the file to prevent any kind of renewal without consideration of this issue.
Okay. Are we ready for a motion then?
Yes.
Okay, we're ready for a motion.
I'll make that motion.
Okay, as discussed.
As
we've
discussed.
1,000 times whatever.
Oh, yes. Do you want me to read it?
Well, no, it's fine.
Okay.
Should be good. 1,000 times whatever days, 8 hours ethics course, and the flagging for the renewal.
Yep.
Does
that
covers everything.
Okay. Yeah.
Okay.
I'll second that.
Okay. Do we have any further discussion? Okay. If not, I'll call for the question. All those in favor?
Aye.
Okay.
All right, Chairman. Looks like we're at the director's report. This should go.
If I may interrupt, Mr. Glenn, it's now 10 minutes till 12. The members have a desire to break bread.
That sounds
if that's
good.
all right with you.
We will recess
your
then.
Permission.
Yes, sir. No, thank you. Well, recess it is then. We'll come back.
We'll be back here at 1 o'clock. I'll be back. All right. Well, what temperature is that? Okay, welcome back. We've returned from lunch, and I think we have a guest that would like to address the board. Mr. Northcutt, if you'd step forward and do so.
Thank you. Emeritus member of this board, I have a request. Education group.
Sorry, go ahead.
Sorry about that. Yes, now we can hear the education group this morning, but this is fine. What I wanted to do, I presented to you all, I guess, a resolution requesting continuing education for hours. And here, I'm going to read the resolution. I have given the board members a copy of that, and I will also give that to Glenn. And then you can take a look at it, and you all can discuss however you think you need to. I addressed it to Mr. Tim Lingerfeld, the Chairman of the Tennessee Board of Examiners for Land Surveyors. By the authority of the Tennessee Codes Annotated 6218-105D and TCA 6218-106D, and under the Tennessee Land Surveyors Laws and Regulations, Standards of Practice, Chapter 0820-5, Continuing Education, I make the following request. Inasmuch as the Tennessee State Board of Examiners for Land Surveyors invites and encourages the licensed surveyors of this state to attend the board meetings, the Board of Examiners quarterly meetings, And whereas licensed surveyors actively engaged in the practice of land surveying are required to obtain professional development hours to renew their registration, and whereas the meetings of the State Board of Examiners for Land Surveyors deals almost entirely with rules, regulations, ethics, and standards of practice by which the licensed surveyors must adhere, be it resolved that the licensed surveyors attending the quarterly meetings of the State Board of Examiners for Land Surveyors and, upon request, be granted 1 hour continuing education credit in ethics and standards of practice for each hour in attendance at the board meetings. Having served a 6-year term on this board, I found that I learned how to handle a multitude of situations ethically and to follow the guidelines set forth in the standards of practice, and I thank you for your consideration. And that's it in a nutshell. So that's why I come down here, not necessarily to get continuing ed, because I like still rubbing elbows with the board and enjoy hearing what's going on. And this morning, whew, what a mountain full of stuff. But anyway, you have it, so you guys can discuss however you want to do that.
Thank you very much, Galen. We appreciate this request. I think it's a good request. Since this request was not actually on our agenda that was published to the public because of sunshine rules and so forth, we actually can't do a vote on it, but I think we can discuss it, and that's appropriate, unless staff corrects me. We're getting plugged up here, unplugged, moved, or something.
Yes, sir. We can, as a matter, since there was flexibility or flexibility that was requested in the agenda, if it would be the pleasure of the board, they can make a request or an action based on that. However, that's at the will of the board. But yeah, very well. We could, at the very minimum, discuss it.
Thank you very much, Glenn. In reviewing the basic requirements for continuing education, I duly note that 0820-05-.03, paragraph 1, subparagraph C, and subparagraph F generally speak to this particular situation. It's not a situation that we have specifically addressed in the manner that Mr. Northcutt has presented it before, but it's kind of, in my opinion, that we sort of have this taken care of in a way. Under C, it says presenting or attending qualifying seminars, and I'll go on through, and presentations made at meetings. Well, clearly we're a meeting, and as Mr. Northcutt aptly said, and being a former board member, he very well knows that we do discuss a lot of ethical and standards of practice things, particularly in our legal cases and in other cases and in other matters. So that particular subparagraph does not specify an amount of hours or anything of that nature. Paragraph F does specify limited to 2 hours per organization if that registrant is a particular officer, etc. So I think that what Mr. Northcutt is asking could be a board interpretation because clearly from the moment that I've been on this board, we have encouraged licensees to come and attend. From time to time, we've had many come and attend, and I don't know of any of them that have attended that have not went away with a positive take from having been present at the meeting and so forth over things that we went over. So it's my notion that we kind of have it in there, but maybe we need to, and I know staff hates this word, maybe need to have a policy about it or something of that nature to better define what maybe one of these subparagraphs speaks to. Now, that's just my notion, and that's just thrown out for discussion. So, Jay, you and Jackie, got anything?
Yeah, chime in real quick. That was my original thought was the same as what Tim just read from the rules there, that seminars, meetings, things like that are covered. And what I'd like to do is basically project that out to the other surveyors that are watching this and let them know that meetings that they attend with direct relationship to professional development are covered. However, I would strongly recommend to them that they make contact with the board before they use that as qualifying hours towards their renewal, just to make sure that, yeah, the board does recognize it and says that's okay. Whether you want to do that before you attend the meeting or after, that's up to them. But just like what you're doing here, you're coming to this board and asking, would this qualify? I would suggest that to the other surveyors as well that are out there. But yeah, I think I'm in agreement with Tim that attendance at this meeting here certainly qualifies.
I'm all aboard. The only question I'd have would be what kind of administrative responsibilities would we incur?
Could it be I would assume that the sign-in roster is probably scanned and put in with the minutes of the meeting in your all's files or whatever. So in my mind, it could be as simple as, used to Mr. Northcutt as example, he signs in his Galen Northcutt license, whatever, puts his number in there, that he is in attendance. And if he was so audited, that's the process we're going to, then he could present that of having attended October 24th, 2019, and he was here for 2 hours or whatever.
That would work, other than you do have people from time to time that leave during the meeting. So on that same roster, we'd have to have a sign-out sheet. Yeah. In order to know how much time.
And I don't see that as, this whole scenario, I don't see it as, all of a sudden we go from just Mr. Northcutt here to 35 people in the room. I don't see that necessarily happening. I wouldn't either. Right.
Time I spent on the board, it just doesn't seem that way. But there again, and I have signed in here with my license number on it. So if there is any ever question, and I think that's probably how it ought to be handled at least from the administrative standpoint. Whatever you all choose to do, that's very simple. Other than it just needs to be reviewed when it comes time for any.
And if it's my notion that if we need to have some kind of motion about it, or whatever, at our next meeting, then we could address it at that time. And I think Mr. Northcutt aptly said, there's no apparent urgency at the moment, so it's something that he just wants us to consider, and I think it's a very viable consideration.
Got that listed down as our action item then for the next board. Thank you, Mr. Hunt.
I'm going to exercise another option. I'm going to take to the air here in a few minutes.
Sir, thank you so much.
Thank you, Galen.
Your words.
You're welcome, guys. Thank you.
Yes, we'll include that in our action item then, administrative and legal. I think the only question, obviously, CE is broad, but then that 2 hours is more particular. So then we'd have to just look at that. But other than that, we'll have something for you at the next meeting, and then we can dial down and then come to some sort of a resolution in regards to that.
Appreciate that. Like I said, just something for consideration. I think it's a good question.
All right. Looks like we're ready for the director's report then. Okay.
Is it on the iPad, Jamie?
Yeah. Okay. Page 23. Let's steal this mic. All right, page 23, and we've got 3 pages to look at. It's that time of year again. We have our end of the year fiscal numbers. So we'll do a big snapshot, if you will, and then we'll drill down and hit the trend analysis for this fiscal year. And then hopefully, as you compare the two, you'll get an idea of both of what we've done the last year and also what our overall fiscal health is. So what we're looking at here, this is nothing new to you folks, the reserve balance. You'll recognize those line items. Right in the center there, you have expenditures, and those are expenditures that are itemized in Edison. And then right below that, you have additional expenditures that don't have line items in Edison, but are shared among various programs and sometimes specific to this program as well, for an overall total expenditures. And then below that, of course, revenues, and then with that reconciled, the overall balance at the end of each fiscal year. As you know, it's no secret that we always typically do better on the renewal years, primarily because the revenue stream is going to be coming in on those years in particular. So that's why you see that trend there, where it goes up, down, up, down. Of course, being the up is the renewal year. So last year was an off year. We're coming into a renewal year, So we expect that after this fiscal year, this upcoming fiscal year, that reserve balance will reflect that as well and continue to trend in that direction. But overall, we're doing well. We're actually hitting our projected trend and then adding a little bit to the reserves as we go. Now, we're not in the habit of creating a savings account either, so we always, it's a balance. We do that. The sunset hearings talk about that along the way, but nothing sharp in either direction. So we're tracking right where we need to be. If you look at the trend analysis for this past fiscal year, now of course that's your month to month. The surplus deficit, as you see, it's a off cycle, so it's going to run in the red. I didn't see anything that just jumped out at me. Let me take a look. There was maybe one particular item. January, you had a spike in the other category under Edison for $8,000. That was the only thing that I looked at, and at that account, that's third party services, and that was at the time we were moving, and so there was a lot of things that wouldn't necessarily fit into Edison, not regular expenses, kind of a one-off. A lot of the programs experienced expenses that come with movers, contracted electricians, and program shares of that as they make those adjustments into our new space. So I don't foresee that we'll see that again. So every once in a while you'll get a reallocation where there might be one big expense, and then they look at the various budgets of the programs to see how they're going to proportionally divvy that up. So that happens every once in a while, and it doesn't appear that that's what this is. So it appears that it's all remodeling and movers and consultants and the like. So that's where that's coming from. I didn't see anything other than that outside the ordinary. We're right at a pretty good place in regards to that. And then that last page is another list of the accounts that typically we pull out of Edison. Would be your Edison accounts. And you'll see that same spike on January.
Could I ask one question, Glenn?
Yes, sir.
On the first page, I guess it was 23, case complaint revenue, I understand what that is. The state regulatory fee, the reason I asked that question is I noticed that every other year it's a large number as opposed to being a small number. Is that relative to somehow another Edison's done, or what is that number relative to?
Talking about the case complaint.
Right underneath it says less state regulatory fee.
Oh, okay, great. Okay. I see where you're tracking now. The state regulatory fee, that is basically a workaround. It's an accounting term they call reduction of revenue. To me, it's an expense, but in accounting world, there is such a thing, and it's basically where they don't consider a true expense in the accounts column, but if they do a workaround, that's not what they call a true expense. Like, for example, we don't print our own licenses. Fiscal and administration does that. Well, so it's not a true expense, but because of that internal workaround, it's a reduction in revenue, and that's what you're looking at.
Okay. Thank you.
Yes, sir. There's no action on this. It's just informational purposes, but of course, I will entertain any questions that you have.
Yeah, we're just always concerned about that because of the 2-year renewal cycle and making sure that we do have enough monies to balance everything. I know the governor's very concerned about raising restaurants' fees and things of that nature. So we like to monitor that so we know we're got a little bit of a safe blanket, I guess.
Sure. No, and we're fiscally we're sound. Okay. So, any other questions? Okay. We'll move on then to the complaints report. That's right behind this one as well in your presentation. You're looking at page, let's see, 26 and 27. Nothing really to discuss here. It's just basically a listing, an accounting of those complaints. So that's also for your informational purposes.
Doesn't look like any long outstanding complaints going on there. So they're pretty.
The first one on the bottom of the first page is the one that we throwed around this morning. Whoops.
Any questions on that? Okay. And then just a letter for your review that Roxanne sent that to you as well, just in discussion about, looks like conversations that she's had with various outreach or the Director of Public Affairs there at NCWS. So instead of reading that into the record, just letting you know that we're still looking for those opportunities to share the profession of land surveyor with others and to continue to expand that industry where possible and make our contribution to that end. That's all we had for the director's report. Unless we had anything else that you'd like to discuss in regard to those items, I think we're free to move on to new business, if that be your will, Chairman.
Yes, sir.
Okay, course reviews. We did a little bit of that already this morning. So we did some heavy lifting there. So it's a great opportunity to segue and have that discussion. And as you know, we had a little bit of a backlog. It can be times challenging to move these things along in an efficient, productive manner at times because you've got so many stakeholders, and some of that is intended, and so. But in regards to the backlog that we did have, and then trying to evaluate our other programs, one of the benefits of having several programs is you can borrow from their best practices as well, and thoroughly examine that and see that through. There's a couple solutions that we'd like to offer to move these through the pipeline a little bit quicker, and a couple of those, like the appraisers. Well, I'll give you a couple of the ones that we do it. Well, I'll just give you two options, then I'll give you the examples. The first option is we would like the administration to have the opportunity to approve those listed and then grant credit. And whatever questions that we may have in regards to that, of course, we would reach out. We'd get some criteria, from the board about where those parameters lie. But then at the same time too, and then use the board as an advisory to that end as well. But go ahead and approve those, kind of like what we heard when Mr. Lucas was discussing Florida. It doesn't have to necessarily be to that extent, but some variation. I mean, we can be creative and figure out some way to do that. So that's one option, is to allow the board to approve those, or not the board, but the administration as extension of the board to approve those, and then they would be approved, and then they would come to the board for just basically formalization of that report. That's one option. We can also bring our recommendations to you for final approval at the meeting as well, to kind of fast track that as well, having had those kind of conversations as we go. I do think that there's an expertise here that particularly now we can take advantage of to that end, primarily because one, our executive director being an attorney and can look at that criteria and really examine that with the benefit of that experience. But then also we have an admin manager that's spent the last year and a half approving courses as well. He's worked with the home inspectors. They have a pretty hardy criteria and very particular criteria for what they will allow and what they won't, and he's been able to examine those. So in concert with our executive director and with the criteria articulated in statute and also with guidelines provided by the board, they can go ahead and start approving those courses. And then, and if we have any questions about certain courses, then of course bring those forward and then memorialize that report. But they will in effect they'll be active as soon as they're approved. That way, we have that within a week turnaround. So that's an option. It's for discussion. Would love to hear your thoughts on that. Appraisers do some variation of that as well. There's two options. There's home inspectors where that staff approves that, it goes out. Appraisers, they approve it, goes out, but then it also comes before the board. Both would have to come from memorialization. So in some essence, they're pretty much the same. The only thing we could get hung up in that is if we've already approved one and it's active, and now we have to there's some disagreement about that after the fact. So I wouldn't want really a situation like that. I think it would be best. I think the board would be best served if we were to go that route, where there is some criteria guidelines provided, and then those are approved and go out, and then we're just memorializing that on the record. I think that would probably be the best way forward. So, of course, that's up for the board to decide, but that would be the recommendation of staff. Comments, concerns, questions?
Well, I'd kind of pitched an idea to Roxana prior to her exiting stage right concerning this matter relative to the possibility of pre-approving sponsors as opposed to courses. Now, pluses and minuses on this, and I understand that. Trying to find a way of, addressing this situation, because I don't want to say our system's broke, but I think it needs a little bit of help.
Roxanna and I actually were able to discuss that a little bit. And my concern for that is that while we have some very capable and wonderful providers, I would hate to do a carte blanche just based on the vendors without looking at the actual course on the merits and worrying that we might be precluding someone who we aren't as familiar with, but their courses are appropriate.
Well, I spoke with Andrew Ritter, who's the MBA in North Carolina, about this, and this is kind of the process that they use over there, is pre-approving vendors as opposed to courses. However, the vendors not only have to substantiate who they are, what they do, and so forth and so on, they also have to provide a syllabus of a certain percentage of their courses to praise or guarantee the board that they're doing what the board's really wanting them to do anyway. And that's sort of their approach on that. And that's an annual thing for that vendor. It's not a, like Mr. Luke, I'll use him as an example. It's not, he shows up and, okay, we approve you, Mr. Lucas, and he's approved forever. That's not the way it is. He has to do it every, which basically right now is what we're doing with his courses anyway. So that's just a concept. That's all I'm throwing. I'm just pitching a concept to try to find some way to help handle this.
We there's a couple boards where it's a variation of both. Don't know if that's, I'll just tell you what they do. Auctioneers, they approve National Auctioneer Association courses, so that would be the vendor. But then they also have a caveat for staff or to evaluate, and board or extension, by extension, the staff to evaluate that as well. Court reporters, they have vendors, associations such as National Court Reporter Association, Tennessee Court Reporter Association, and they also name other entities as well, like universities, things like that. But then they also have a criteria for staff. So it seems like when they go that route, they're at the end of that train, that caboose is staff approval as well. So just to keep that in mind.
Well, and see, it's a point that we argued when we redid our continuing education rule. Is I felt strongly that we ought to be able to actually charge these people for these courses, some type of fee, because I feel like not that the money necessarily makes a difference, but I think it changes the rules of the road for them. They're not going to invest in something to get approval on if it's not, it's not. But I know that money's kind of off the table with the governor, and I understand all that, But like I say, I really feel like, and I think North Carolina does charge for their vendors a vendor fee, So I think potentially without the dollars involved, my concept is not as strong maybe as one that you have presented.
As far as to continue with the discussion and to track that progress, is there anything that further that you would need to make that determination, or is there some variation of that you think that the board feels that they would be in favor of? What's the temperature of the board in regards to that?
I don't think it's any secret that I've come up here and tried to have a few courses that have come through us denied for whatever reason. And so, yeah, I take each course personally. What I don't want to lose is the sense of control over the approval process of these courses that come through. And I'm talking about me personally. I take it as, I want, if I'm going to be part of this board that's approving the PDHs, ultimately, I would like to have some sort of hands-on still. That's just the way I work. So what I don't want to lose, whatever process we end up going through here, I still think ultimately each course needs to come in front of my eyes at least, and again, just talking about me personally, just so I, at the very least I can see the title of what's being presented. I don't like the feeling or the concept 100% of the carte blanche because it's XYZ provider that anything that they present in front of the board is it's good just because we know who you are type of thing. I'm not comfortable with that yet. If the idea is to try and expedite the approval of the PDH providers, perhaps the solution is, all right, let's take it out of the hands of the educational reviewer system that we have already and let it just come in front of the board much like we did today. I mean, quite honestly, what we did today was, some of those courses I hadn't seen before, I was able to see the topics. I felt comfortable with what they were. If I didn't feel comfortable, I let it be known it was either deferred or denied. Let it come back again with some better summarization of what it is they entail. Personally, I don't have an issue with that system that I just said. Let it come in front of me in terms of just the title and provider alone. If I need more information, I'll go back and ask for it. Otherwise, it'll either get my approval or denial, one or the other. That's just the way I work. I'm more hands-on. These guys here in the administration may think otherwise, and perhaps your system's better. I'm not saying mine's any better than anybody else's, but that's just the way I feel about it. I'm more of a hands-on type thing.
I was a little bit hesitant to approve them just on the title. I mean, I'd prefer to see the
title and hours. And hours, I should have said.
Title and hours, yeah. Prefer to see the syllabus. Approved administratively sounds pretty good also, but there would be the occasional one that maybe doesn't fit the criteria that we would establish for the administrative.
Is there a way to, and these are actually really questions, not propositions, because I really am asking you since I don't know. Is there a way to determine these are standard courses that are offered every year, whatever 1, whatever 2, 3, 4 I saw on Mr. Lucas's, that we know that it hasn't changed, the class itself hasn't changed, and so these are some that we can already know that these are stamped for approval, unless for some reason the curriculum changes drastically, that staff could say we can approve those, and then anything above and beyond that, we could present it to the board. Or if it is presented to the board or the advisory or however we decide to move forward with that, and there is not a response within a certain amount of time, then the staff is able to authorize that or something of that nature. Is that even possible?
I think it's possible. I'll just say this, the CER numbers, and correct me, Jamie, if I'm wrong, are good for 2 years, if I'm not mistaken. So
Away with the CER numbers now.
Okay.
So it's actually the file number is the course number. We don't have the CER.
What?
What about,
go ahead.
Go ahead, I'm sorry.
I was just waiting y'all got done.
No,
go ahead. No, you go ahead.
I didn't want to, since we're passing that baton to our new executive director here, I didn't want to propose something that she may not necessarily want me to be proposing. And so anyway, what about, right now you need, the policy is that you have 2 board members to approve, whereas if you have 1, you defer. If we have a variation of all of what we're talking about, the staff is 1, another board member 2, it passes. And then it comes for the memorialization, it gets its CR number and it moves on. Is that a possibility?
Let's back up just a little bit, if we can, just for my edification. I'm kind of slow. I'm from the Northeast, so let's look at the world that we're in, okay? Let's talk about history just a second, and let's go to where we're going to be shortly. Historically, Tennessee was the last state to go away from a 100% audit of continuing education. Heretofore, we did a 100% audit. we made sure that every licensee that paid their money submitted their continuing education hours, and every single hour was audited to make sure they complied with our rules and regulations for license renewal. Okay? That's history. Okay? We now are in an environment of where coming November 1st, all of us as registrants will receive a notice that says, hey, it's time to renew, and there will be a piece of paper, basically electronically, that's a statement that says that we, all of us, attest individually that we have the hours that are required, the 30 hours biannual, which include 2 hours of ethics and standards of practice, that we have met that criteria, and we submit our check or credit card payment or however we choose to make that payment to the state of Tennessee. Okay? Now, we are in a pool. In this particular case, we didn't get any numbers today from the director's report, which that's something that I always like to have, what the numbers are as far as total licensees and in-state licensees, just FYI. That keeps us up because we're asked that a lot when we're like at NCWS meetings and things of that nature. But now we're in a world to where we're all going to pool. Let's just assume that there's still 1,100 licensees in and out state total. We all go in a pool, and 5% of us are drawn out of the hat. That 5% is audited. That's the only group of licensees that have to step up to the plate and prove anything, okay? Unless you're one that does not properly renew prior to the end of the year. If you don't, that's an audit. So it could be 5% plus another group that were delinquent in not paying, okay? Or it could be anybody that we have a complaint against, or a couple other little things, okay? So when I look at that, if I'm going to use the number 1,100. 5% of 1,100, I think, is 55. I didn't multiply it, but I think it's what it is. So 55 surveyors are the only ones that's going to be audited. So the reason I broached this in this manner is, now let's talk about continuing education and course approval and how we get there, okay? All right, let's assume that Tim Lingerfeld is one of those 55 that gets audited, okay? Let's assume that I supply my coursework and it's found to be deficient, okay? In some form or fashion. Somewhere in that 30 hours, I am deficient for any or all, okay? Now, I have, was it 90 days we decided, or 100 or 120? I'm trying to remember. We have a window of time that staff sends me a notice that says, okay, Mr. Lingerfeld, you've been audited. We've reviewed what you've sent us. We find you to be deficient in this number of hours, etc. You now have X amount of time to rectify this. Okay? Now, I'm trying to talk about the world we're in today. This is what's happening starting January the 1st. Okay? So the whole purpose behind this conversation is, with this changing world that we're fixing to go into, we're somewhat, and I agree with Jay, I'm old-fashioned as anybody here, because I still like the 100% audit, to be honest with you, because it kind of makes people that don't want to be accountable more accountable, okay? So, but having said that, I think that new world that we're going to with our licensees and the renewal system, so forth, the attestation, so forth and so on, and having that ability to catch up or get the ones that you never got to start with, or whatever the case may be, if you're audited, then I think we need to look at this other process, and we are, but I'm just trying to pose it in my little mind. We need to look at this other process in a little bit different light, because at the end of the day, it's a privilege to have a license, but that license has responsibilities. And those responsibilities are renewal, teen education, etc. So we are truly putting the monkey on the licensee's back to perform the way they're supposed to by state law. or state statute, okay? So that's why that I'm trying to look at some form or fashion of this continuing education that somewhat makes it smoother, quicker for, in my case, for the vendor, because they're the ones that ultimately bring the courses up here, whether we break them down from 1 to 50 in courses or where they only have one course. So I'm trying to make it smoother because we got all this other stuff going on. We're in a different world than we've been in. Heretofore, when we were doing 100% audit, we wanted to make doggone sure that every course they took had a CER number. We looked at it, we touched it, we talked to them, whole 9 yards. I'm not so sure that in the new world we're going to, that we still have to do that. And I'm not proposing something less than, by no means, but I'm just throwing that out for your consideration. Because that's the way I have to look at it, is we're changing the rules of the road. So maybe we need to do something more different than we typically would have done had the rules remained the same as they were last year, or last renewal, or renewal before that. But those aren't the rules anymore. That's my soapbox, and I'm going to get off of it. I hope I'll make you think a little bit to help compare that.
Well, of course, we can table this piece then and reconvene. It seems like it doesn't look like we're ready by consensus yet to move on this piece, unless I misread any intentions of the board. I don't want to speak for the board, but I didn't. Is there a consensus in how we want to move forward? Are we still in discussion as regards to that, or is there maybe some variation that we'd like to offer and send to staff to review and then bring back again? What would be our marching orders?
Let me ask a question. I want to back up just one step here. I think what brought all this to discussion was kind of more toward the expedience of getting the courses that are submitted by the providers through the system, approved or denied, a decision made, and then out there available for the registrants. The question is, do we have a designated timeline set for when we transfer the application of the PDHs to the reviewers? Do they have, like, look, you got to have these back in 15 days? Or is it just we provide it to them and it's kind of at your leisure, so to speak, get it back to us? Because if the issue is expedience, let's put a deadline on it and say, look, you got 15 days from when we get it to you to get it back to us with your decision or review or whatever you want to say. That seems to be kind of we're trying to make a mountain out of a molehill here. Why don't we just try and expedite the process a little bit with a little nudge on the reviewers saying, look, I need 15 days, I need this back, or 15 is just arbitrary. I mean, 7 days if you want to make it. That's my question. Do we have a? No, I didn't think so. I didn't think we did. Is that something that we think maybe would encourage? I'm not saying it's a solution, because they might just go, hey, I'll get to it when I get to it. But, if they're not providing in 15 days, maybe we can find someone else that maybe will
Under
provide
normal conditions, I mean, this huge amount right now, I
it's getting toward the end of the year.
It is the end of the year of a renewal year.
Oh, yeah.
But under normal conditions, they get back to me pretty quickly. It doesn't go 2 months with no response like it did this time. And but normally it can be 30 to 45 days before I get to answer. It usually hits one will be immediately, and it can take some time to get a second approval on that.
The difficulty would be enforcing some sort of a timeline like that. But
I mean, no enforcement really. I mean,
right,
other than thanks, but we'll find someone else to handle the services.
Right.
But I don't know. I guess what I'm asking is the system really broken, or does the system just need a little encouragement to work better? Does it just need a little oil on the gears, or do we need to tear down the machine and rebuild it?
That was kind of my question about the system is, as far as enforcement, if we don't have a response within, let's use your 15-day period, then does it default to staff? to me, that might be a solution so that it doesn't get clogged like we did. And I'm just coming in on this and seeing and not knowing the mechanics behind it, but perhaps that then it defaults to staff. So it's kind of the variation that Glenn was talking about.
Staff, and I sense that staff is more than Jamie.
Staff would be the staff would be Ms. Peck, and it would be whoever she would choose to aid her in that regard as well. I imagine Caleb would be a party to that, and I don't know if Jamie would be included. She's got so much responsibility with the licensing piece of that, but there's enough experience between Caleb and Jennifer to handle that part of it, in consultation, of course, with the board.
Well, and I would encourage Ms. Peck to also how the engineers and architects do theirs, because they have to have. And if we've always been big about if that group is doing something a certain way, we try to sort of do it pretty similar because that helps you all, especially for you, and that's going to be director of both now.
Yeah, so possibly what we could do is I can speak with Jamie and then also get with Caleb. We can try to get a timeline for once we receive the information, how quickly we get it to the reviewers, and then once the reviewers receive it, how quickly they get it back, and then what the default is if they don't to a staff member, either Caleb or myself, obviously in communication with the board about that. But maybe we could get some sort of procedure in place and be able to talk about that next time.
The only I guess caveat that I would say, not really a caveat, I think that's a great plan. I would just say once the decision's been made by the reviewers or by staff, that would go out and be approved, and it would be available for CE. So I mean, basically, what we'd be presenting here would be a report. It wouldn't be us, going over that and sort of litigating that piece. That would be the only.
It's basically the way we've operated,
right.
Except for courses of question.
Right. No, that's great. And having not been here for the last few meetings, I just I'm putting that provision in there. Not sure how the board has historically in the last few meetings handled that. So that's a comfort to hear that would be the case going forward. Okay. Is that kind of where the board's going then with that one? We want to put like a timeline, and then if they don't meet that timeline, then staff, in this case Ms. Peck and her designee, or Ms. Peck, if she has all that she needs to make that decision, would administration be making that decision in lieu of the education committee being basically an extension of that committee in this board?
A modification to the system we have now that I think we can adjust to and work with. At least give it a period of time to see if it works and if there's any flaws in the system there.
What would be the period that you would like to do that? Like, what would be the amount of time you'd like to give the reviewers?
I gave the example of 15 days. I think that's adequate.
And I think too, Glenn, you're going to find that once we get to January 1, these courses are going to just. Like Jamie said, we're at the end of a renewal year. Everybody's trying to get them crammed in so they can get them given between now and Christmas, basically. And that's pretty standard. We've seen that. I know Jamie has since she's been with us.
Would it be the board then 15 hours and then, or not 15 hours? That's really fast turnaround, isn't it?
You're good.
15 days in, and then if the education committee doesn't respond in that regard, then Ms. Peck then would make that decision, then present that before the board.
She could consult with us.
Of course.
Yes.
Yeah.
Yes, certainly.
Right.
Yeah.
If there's any fuzzy areas, we're definitely going to reach out to the board. We're not going to sort of just make it up as we go. So, all right, if that's the will of the board, then we'll just need a motion in that regard that would be your will.
I'll make the motion.
Got a motion, everyone?
We have a motion and a second. All those in favor?
Aye.
Okay.
All right. Thank you very much. Looks like we're moving on to comedy applicants, and for the rest of the remaining of this of the agenda, we don't have anything further on the iPad. This would be ongoing discussions that the board has had since the last couple meetings. So I'll leave that to you to direct that.
On the comedy applications, I think I brought this up. My goal here was to do the same thing that we just tried to do with the continuing education, is to see if it's possible to streamline the process. However, I'm a little reluctant to my discussion after the discussions that we had earlier with a couple of applicants. My theory was, I will broach my theory. My theory was, if an individual was licensed in another state, number one, taken the NCAAS exams. Number three, they met our educational requirements. Number four, they have a clean disciplinary record from their jurisdiction of licensure. They met those things and they applied for licensure in Tennessee, then we could give them their license by comity. They would go through the regular application process, pay the regular fee, etc. We could give them their license by comity if they met that criteria. And there could be other criteria. That's just four things I listed right off the bat. And the thinking behind that was to streamline the application process, because right now I'm going to estimate that we're somewhere between 60 and 70% of our applications are comity. Out-of-state people. And I don't know if Jamie agree with that number.
I agree with you.
Okay. It's somewhere in there. I don't know. I don't have the exact math, okay? But it's somewhere in that range. So basically, we're taking 6 out of 10 applications pretty much out of the system if they fit a specific criteria that the board would establish. And this kind of comes about from NCAAS. And to give you an example for you, Ms. Jennifer, is the state of Kentucky just this year eliminated their state-specific examination. If you have taken both of the NCAAS exams, the FS and PS, the mindset behind it is several things. One is eliminating state-specific exams. Two is trying to promote the NCAAS exams to where they're more. But three is also the mindset from enforcement is the fact that, let's just say that we agreed to my proposal and we licensed someone that was out of state and now they're licensed in Tennessee. Just as Miss Erica has went through, if there's problems, somebody's going to file a complaint, this board has the ability to deal with that individual. And part of the concept also behind it is, if surveyors are truly ever going to be known as professionals, it's my have to have a little bit of leeway to get there. And this is one way to give. For example, if I go to the engineering world, okay, if I'm licensed in Virginia as a professional engineer and I apply to the engineering board upstairs to be licensed in Tennessee, they give me my license by comity because I already have a PE, okay? They don't ask me to take a no rules and laws exam, nothing. They say, okay, you are a professional, you're a professional engineer, you're now obligated when we give you this license to go by the laws and rules of the state of Tennessee. And if you don't, you have to appear before this board. And basically that's what I'm saying on these particular surveyors. I'm not talking about new applicants, I'm just talking about comity applicants that could fit some type of mold that we could shape. If they fit in that box, then let's give them their license and let's move on. So that's kind of what my discussion is. So my friend on the right here, Devil's Advocate, he's got his idea.
Well, in my opinion, it certainly has some merit. I think it's certainly a move that is growing. I think probably as years go by, more states may adopt that, like Kentucky has. I think New Jersey possibly.
New Jersey is back on the board.
Are they? Okay.
Yeah, they're back on the board.
All right. My concern, as is all of ours, I'm sure, is paramount, is obviously the protection of the public here. My concern is that the complaints that the board receives are few in relative to the number of surveys that are performed in any given month or year time period. And oftentimes, I think a lot of that is because oftentimes the public is not aware of the standards that should be on a survey. When a surveyor presents it to them, they look at it, and whether they like it or not, they think it's great, whatever, they're not aware of what those standards are. It may be deficient in many ways, and they're just not aware of it, so no complaint is filed. It's fine. So my concern is that the comedy applicant that fits that mold has not ever been formally tested to the Tennessee standards, which are different than any other state, right? That has a set of their own standards, very similar in many ways, but different. And so my concern is, as a board, isn't that our paramount responsibility to have ensured to the public that the applicant, whether comedy or new, has passed the three-legged stool, right? The education, the experience, and the examination. And with that, I take, as we all do, great responsibility in sitting in one of these seats here, that we are protecting that public, and we have done so by examination for the standards that we are responsible for, the Tennessee standards. And by not testing each and every licensed surveyor that comes through that door that is performing surveys out there, without knowing that this board, whether current or past, has approved them, kind of leaves a gaping hole there for me, in terms of my confidence that me sitting in this chair allows them to be a registered surveyor with the ability to protect the public and provide the best that they can. I'm not discrediting other surveyors from any other states who are probably better surveyors than maybe all of us here, who might be the best surveyor in the world, might follow every rule and regulation to Tennessee surveying across the board. Best one ever. But it just takes one. It just takes that one that, because he fit in the mold and was a super surveyor over in another state, that comes to Tennessee and says, yep, I'm going to take it, but I don't have to review the rules of Tennessee. They gave it to me. And now he's outperforming surveys across Tennessee. Maybe the best ever, maybe not. That's my argument against it.
I understand.
For now.
I think if you'll notice statistically, and Jamie can correct me, that last report that I had, we had only had one failure on our TS examination.
Mm-hmm.
So basically what we're asking folks to do on a 2-hour TS examination is to read that.
Exactly right.
And then regurgitate it on an examination that's 30 questions.
But I know they read it.
I understand that. But at the same token, I was asked this question in South Carolina when I presented the concept to them. And the thing that I added to my mold was a attestation statement that said that they had read those. Matter of fact, I talked with another state, and in that state, they said, in what you're talking about, could we send the applicant a take-home exam for our rules and regulations? And I said, I see no reason not to. But at the end of the day, it improves the comedy licensing process. And that's kind of where I'm getting at. And if you think about it, if we took 60 to 70% of the applications out of the equation because they were able to fit in that mold, if all of them were, all of them might not be, then we limit that basically to the in-state folks that we really and truly want to do this because they've never had a license. We darn sure want to make sure that little Johnny or little Susie that's never been licensed. We're giving in some. We're giving in some assumption that Bill and Jane are going to be professionals and do what is right because they're already licensed somewhere else. I agree with that, but we're just throwing this out for conversation to look about how we do it. We're very fortunate that we have a CBT examination through a national vendor. We're very fortunate because there's only a handful in the whole United States. So we're really very we've went a long ways. It's my ultimate goal with the changes in the PS that were probably 5 years out that but we're not there yet. But simply pitching out a concept to think about the possibility of maybe making some changes to hopefully, make our But, I don't disagree with any comments you made.
Yeah,
They're very valid.
Yeah, I think it's great for discussion. I would like to encourage anyone that's listening and take it amongst their fellow professionals. Certainly, I think this is a great discussion for TAPS. I think it would be a great discussion, whether it's in their local chapter meetings or at some other venue. I'm not saying that this won't come about. Certainly, that could change over time. Perhaps if other states start adopting it, you get more comfortable to see how it works. I would be very interested in Kentucky after a couple of years to see how their complaint system looks after a couple of years once this is in system. It holds merit. It holds merit, but I'm not ready for it. I'm not there yet.
I understand.
This may be getting into the weeds, but as a part of the attestation, not only that they've read the standards, but they agree to abide by those standards. And would that be serving the public in an acceptable manner from our end, that the person as a professional in another state has agreed, attest that he has agreed, not only that he's read them, but he's agreed to abide by those.
And see, I don't even think the engineers go that far when they do comedy, do they? You can check on
Asking you
that.
another
I'll look
30
at it.
days.
I'll give you 3 months. How's that?
90 days, I'll take it.
I've seen different attestations. We were trying to get away from what's a lot of our programs, away from notaries that weren't required because that's a little bit more cumbersome. So we went to a lot of attestations in a lot of our programs. So a lot of the programs had varying language that the attorneys would provide based on the needs of those boards. So certainly we can look at the language on the attestations. It looks like we're all in agreement, and when I say we, the board that sits across the divide here, the experts seem to be in agreement that we want them to have read the the standards of practice and the Tennessee standards. So it doesn't look like, at least there's consensus there. It's just a matter of process now, and so I don't know. Did you have any action that you wanted to take today, or
No,
just
this
okay?
is a discussion topic.
Okay, very well. Is there any other comments or in that regard? Thank you. Application review process.
I would ask Miss Jamie, are they going pretty smooth? I mean, have we kind of got the bumps out of the road on it?
We have, as far as like SharePoint and, getting the product to you and everything. Sometimes it takes a little while to get 2 answers. Or if I get 2 answers that are not consistent and I have to get a third, I know you guys are busy as well, but that kind of holds up sometimes where, I process. And I do want to let you know that I speak to every single applicant that comes through and pretty much email them all, and I do send them a PDF of the standards of practice. They inquire about what are the rules for the plats and how to apply. They do get those from me, and they get your sample. And that, I do want to say that because they all get it from me. They don't have to look up online on the website. They get it in an email from me, whether they come through customer service or it comes directly to my email that is sent back to them.
That's good to
be
know.
aware of that.
In a way, it's reassuring, and in a way, I'm almost a little upset at it because, number one, I'm reassured because you're taking the extra step. You don't have to do that. It's available to them, and they should, as the professional, be able to reach out and get that information. On the opposite side, it's a little upsetting because, a lot of these plats that I'm getting that I'm either deferring or rejecting is because they're not applying the minimum standards that now I'm finding out that you provided to them above and beyond.
I provide it to them.
So kudos to you for taking that extra step.
I try to help them.
Not so much on the plats.
So that they have it all in front of them,
Right.
what they need to do. But one thing I was going to ask, if you do make changes on the commodity, them do a plat.
They have a similar process to the process I described, and they do.
We don't currently do that now, so I don't imagine that we would. I think the idea, it seems to me, that was to streamline the process and unencumber. So I think that's really the direction that we're intent that we'd like to continue tracking on, and it seems to be historically where we've come from and where we're going too. So for that, I do appreciate. And it's not just land surveyors, which we've come quite a ways, and over the last several years, a lot of that just to adjust the industry. Like you mentioned, NCWS, a lot of things are coming out of that. We've seen that in Athletic Commission. The industry is changing so fast, and so you have to keep up with it. And so that's really been the goal there as well. And especially when you look at the public interest, it's sometimes when we were adding, we had, before we got our rules, I think, in line at the Athletic Commission, we had a lot of additional rules, but they weren't actually making the public more safe, because the industry was changed such where there was new information, new reports, new data that showed that was outdated and outmoded. So I really appreciate where we're tracking, and I just want to encourage us to continue in that vein. But right now it looks like we're getting these out, and these are coming in and moving quickly. So for that, I do appreciate your efforts. That's a lot that we ask from our board members, because it's not a lot of folks when they look at these meetings, they see the meetings, but they don't see what necessarily goes behind that. And so it's a lot of work. It's ongoing. It's throughout the last several months. It's not just the week of the meeting and then the meeting itself. And so our appreciation to you for the work that you do in that regard. We thank you. Expert reviewers.
Another topic I pitched out, we have not had the expert reviewers' expectations from the board. Since the original contract, thank you, Jay. Since the original contract was written, we have a unique relationship because we're not able to be in the same room with those people at any particular period in time, and we through legal or whomever to get to them. So I think it would be prudent if the members of this board were able to review I'm going to say the contract expectations that we originally had with our case reviewers, so that we could determine if there are things that we need to add or, let's say, embellish that the state is asking these reviewers to do on these particular cases. I'm not saying they're doing a bad job, by no means, but I think in some instances, I think that it's possible that maybe they could have looked at something maybe a little more in depth or whatever, because, it's going back history again, Glenn, for what it's worth. I know when Jackie and I were on the board several years ago, we were used to getting 2 or 3 cases at every board meeting, and we took them home, we reviewed them, recused ourselves, and made a presentation to the board at the next meeting, and then the discipline was voted on. And of course, we're far from that now, but we have done that system and are very familiar with that system. So several meetings back, we did have a discussion with legal about the fact that we were not getting enough descriptiveness in the synopsis of the case that's presented, as like Miss Erica read earlier. She did an outstanding job, and I commend her for that. And because, from where we sit, that's all we have to go by. Whatever those words are there. So if there's 10 words, that's all we've got. If there's 1,000 words, that's what we have. So the exactness and brevity of those words is very important to us, because that decides the potential fate of a licensee or a respondent in that particular case. So it's important that we get a good brief. Oftentimes, and we've never seen it before. Really, it's not legal's issue. It's more of an issue of whatever the reviewer wrote. So I just felt like it was prudent that we discuss what the board's expectations of those reviewers are. You know, at one time we had 3. I think we got 2. I'm not sure, but I think we do. Just be good, I think, from time to time as we go through these cases, you know, every couple of years or something, that we review hitting where we need to be, so that we have the ability to make good decisions up here from what we're presented.
We can always take that back to the reviewers. I know that this is kind of ongoing with other boards as well. I can think of 2 right now. I do listen to the minutes of the other board oftentimes. And there's 2 other boards that have ongoing discussions of expert reviews and the content in there, and what they need as a board to make the decisions that they have to make. There is an administrative staffing challenge sometimes to expert reviewers, because oftentimes, at least with the 2 boards I'm thinking of, one of them in particular, it's all contracted. And so you have to have folks that will put in an assets bid and move towards that contract. It can be pretty involved. It's not, and I've sat on that side of it too at the contracts. It's a little more than just a resume, you know. So it's pretty, unless you've bid on one of those, a government contract, it's pretty exhaustive. And so you know, that process sometimes can be somewhat cumbersome, but
I believe that's the way our
That's
reviewers
the way
are.
ours is.
Yeah.
It's contract.
They're contract.
Yeah, they're contracted.
That's why, if we could see the language that's in the contract, at least that gives us.
We don't know
idea of
how
what
much
the
they make or nothing
expectations
like
are.
that, you know. We just want to make sure they get us the right stuff.
right. So, but one thing that I've seen the boards do is they'll take examples, because you know there's general sort of instructions that will go back to these expert reviewers, but a lot of folks will interpret that, you know, in a varied ways, depending on who's receiving that. Then sometimes other than what the board intended. So what they'll do typically in these boards, at least, is they'll give examples of cases that they've had that they felt like more could be added and critique that, and then legal or staff would take that back to the reviewers and say, this is what we need going forward. So that's how we would sort of mentor that process.
To me, the best example of that is years ago we had a formal hearing. Jackie and I were on the board at that time, and the attorney that presented the formal hearing not address all the violations. And I think I was the chair at the time, and I got chastised by the judge because that violation wasn't presented against the respondent. Knew nothing about it. I mean, the respondent sat in front of us and admitted that they were wrong there in that particular case. So that just sticks in my mind from the standpoint of the level of thoroughness that, in my opinion, the expert reviewer should have if a case goes to a formal. It's one thing to have just a couple little things, and maybe it's a minor civil penalty or something, and they pay it and we move on. If it's a little more major and they, bow up and say, hey, I'm going to challenge you all on this one, then, we need to make sure we got.
In those cases where it's limited to sort of a charge that may be missing, and in the case that you referenced, I have seen those represented just for that purpose. I mean, limited scope. We don't represent everything based on information that wouldn't be material to the decision, the end-all decision. Situations certainly where you may be missing a charge, then we could send that back for not necessarily review, but for them to examine the facts that they've already investigated to represent with that charge included in the next legal report as well. So that's a possibility.
I never will forget the judge chastised me and said that that's just like trying to murder. That's not what they're on trial for. But the judge realized that the person had admitted wrongdoing, but hey, it's out of our scope. We can't do that.
Right. Okay.
Yeah, it would be really good if you all could get us at least whatever their basic roadmap is, so that we could discuss that and see if we.
Great, thank you. I've got my action item on that then. Was there any other comments in regards to expert reviewers or questions in that regard? Okay. Jamie, do we have any application reviews? Okay, no application reviews.
Plaques to sign, I think.
That's right. We do have certificates to sign today for those that have met all the qualifications and will be awarded that wall certificate. So that'll be an exciting day for them when they see that come in the mail. Other than that, that's the only business we have left, unless, of course, the board has something.
I do have a clarification that I'm going to need for the renewals, for the auditing part, because we won't have another meeting before all that starts taking place with me. Postmarked by 12:30 or in the office?
I would have to think postmarked.
Because
I would have
that's
to think
Christmas and New Year's, where the mail isn't always delivered here.
Always
I'm
been
Frank.
postmarked in the past. It's always been postmarked.
Sometimes I don't get these, until the second week of January.
Yeah.
I would think postmarked December 31st.
Okay. Now, if it's postmarked after that, are they
They will be
automatic?
They're automatic audit,
Okay,
automatic.
so we're taking the 5% from October to December, is that correct? Okay, I just needed to clarify.
5% plus those that submitted late.
Right.
Right.
Gotcha.
And, we've been running close to 100 over the last, about 3 renewals.
That's exactly how we ran it before, so we'll just repeat that, so that sounds fine.
But they still have the expired grace period, correct?
We talked about that.
As far as I'm concerned, once they're late, their license has expired.
It is expired.
That's what the statute says.
It's expired. Grace is expired. Grace is just for application without the extra penalties. That's what the grace is. But we've got all that we've worked through all that, had that
all that
discussion.
yeah.
So we can go and put that one in the books unless there's anything new. Anyone else have any other discussion or anything they'd like to discuss? All right. Thank you very
Just
much.
had to clarify.
Yeah.
All right. Well, in that
We're
case,
trying to be fair across the board, everybody, equal.
the only thing we have left on the agenda there then is the adjournment.
Well, we won't sign those before we adjourn, or
Sure. Yeah, of course. Yeah, that'd be fine.
if we can adjourn and then sign them. We
Well-
have one other item, which is PDHs.
Hours?
4.5. Yep.
We got 4.5 hours, is that what we got? Motion for 4.5 hours?
Okay, you have a motion second, 4.5 hours. All's in favor?
Aye.
Okay. Now, what Mr. Glenn has been waiting on. We have a motion to adjourn, all right?
Second.
Second, all right. We're not going to leave because we're going to stay and sign these
I think
plaques.
they'll appreciate that too.
And I want to say just a few things. I, again, want to welcome Miss Jennifer. I know you didn't say very much today, but you're laying in wait. You're going to get me yet. I know you will. And Glenn, I know it's your first meeting with us as far as conducting the whole thing. You did an outstanding job. Outstanding. Seriously. And I don't want to forget Miss Erica, because I feel like she has really stepped up to the plate with her legal report, and just tremendous. And I just want to recognize her for that.
Thank you very much.
Yeah.
Yeah, I want to notify Jamie for all her work on the applications that have
Right.
come through. Keep that up as well. Good work on everybody's part there.
Yep.
Look,
Hang on to these, and then
we'll just take a motion to adjourn, and then we did. All right, I missed that. How did I miss that? That's what I was waiting on. All right, thank you. We're adjourned then.